No, actually, if you just want to log in and delete it, and then you have to register. But it's out. I get that from a lot of people. I'm better for me. There you are. All right, so I'm going to drop here and try to go so that you can practice this time. It's really just a matter of sharing your screen. Yep, if you click on it, that's the thing you're going to get that list of questions. So let me get a hold of her and we'll get you set up. All right. Bye. All right, can you hear me through your computer?
Andrea, can you hear me now? I may have to log back in. I changed my speakers and I can't hear anything. Let me log out. I'll be right back.
Me? Okay, let's go.
Other than that, just, if you have questions, you can put them in the chat. It's a fairly open meeting here. We may mute everybody, but you can always mute yourself and ask a question, just general courtesy.
Very good. We like to start our meeting here at Polk County Real Estate Investors Association, PCREIA, with going over what our mission is. And this is so that you know what our intention is about tonight and what our focus really needs to be all about. Our motto here at PCREIA is investors helping investors. And that is our mission. We love real estate investing. I don't think you could be in any group that loves it any more than us. I mean, it is amazing. Where else in the world can you not only make a lot of money, but you can change neighborhoods for the better? You can help people have a great experience having a home, and you can be a landlord that can change people's lives by being good to them and providing them very good services as a landlord. We do this by providing quality education and also by really supporting our members. You'll see that tonight. It's all about members supporting each other. Education, motivation, it all comes from each other. We believe in do no harm. Truly share and support with each other. We rise by lifting others. There is a true power in kindness, and we completely believe in that. That is our corporate culture that we nurture constantly. So I encourage you, if you're not a member of PCREIA, I hope that after tonight you will want to be a part of it, because it's a great, great group. And then I want to tell you about, speaking of a membership, meeting reminders. So every month we have quite a few meetings. Most of those meetings are for members only, by the way. But I want to tell you, if you got one of our emails, it's always in our emails. But like we have one coming up, we have one at noon on November 12th. That's just a 1 hour sort of quick lunch where we get together. If you've got a question or something you want to share or a deal you want to go over or something you want to pitch to the other members for sale, that's a great time to do it. That's on November 12th. And then we have another one on December 10th, is also a lunchtime midday mastermind meeting. And then every third Thursday of the month, we always have something called the Hot Topics Night. On Hot Topics, sometimes we have a guest, sometimes we don't. And it's all about whatever is going on in your world or in the investor world. We go over it. A lot of interchange and sharing is done that night. The next one we have coming up is November 19th at 6:30 p.m. So we have that going on. And then, Susan's here. Susan, tell us about the note meetup.
Yeah, there's a note meetup. I have a note meetup on the second Tuesday of every month, which is the 10th.
Well, wait a minute now, Susan. Say who you are. This is Susan Collins, and she's a fellow investor. Yes.
Yes, yes. And I love notes. And so I saw the need to have everyone basically to give the basics of, so we at this meeting, basically we learn about the basics of notes, how to create notes, what notes are. You can ask questions, you can just sit and listen, whatever you want to know. It's from, beginning soup to nuts, whatever you want to know. It's on the second Tuesday of every month at 6 o'clock. It's on the meetup. And if you want to, you can text me and I'll send you a link. It's via Zoom. My number is 863-934-9441. And I have a co-host often, which is Kevin Shortell, and he's been in the business, big in the business, and he's on there often. So we're very blessed with that. Joe's on there a lot. I think that if you're interested in it, definitely something you might want to check out at least to see if it's something you're interested in. All right.
And Susan, if you would put over in the chat how they can find your meetup, what the name of it is and everything, so people can find that easily and join. Sure, that way you guys can get some updates on when they're having their meetings, and they're doing Zoom right now, and they'll do live meetings when it's appropriate. So that's what we're doing. Great information, good folks there. You'll really like it. Speaking of these Zoom meetings, I just want to tell everybody, we will continue having Zoom meetings and through the end of the year. I mean, we are at the end of the year, but usually we don't even have meetings in December because locally, all of these special events happen usually on our nights that we have our meetings, like the parade, Christmas parade and things like that. So, but this year we will be having a Zoom meeting in December. I believe it will be the first Thursday as well. So be looking for that email And then starting in January, depending on the climate and the situation, we may be starting having live meetings again. So we'll let you know. And the great thing about having the live meetings, Joe is helping us with some IT things and technical things so that maybe we can have those streaming live on the computer at the same time. So that'll be interesting. So you could be able to choose whether it's just computer or you want to come in person. So that we're working on that. Joe is going to be our hero in that department, I'm positive. So there you go, Joe. It's all on your shoulders now.
At least there's no pressure, so thank you.
Yeah, no pressure at all. Now, quickly, let's look at our corporate sponsors. What we do here, the corporate sponsors are critical to our success of being able to continue to bring you our meetings as we do, whether it's on Zoom or in person. It was a great real estate teacher that came through PCREIA once that said, investing is a team sport, and that there is nothing that could be more true. Part of that team is going to be everything from title companies, insurance companies, electricians, I mean, whatever it is, you're going to need people to assist you in this process of becoming successful in real estate investing. So we have corporate sponsors. They pay additional money to be here to tell you about their services. And the one thing I always say is that our organization is small enough that when you see these corporate sponsors that are up here, their banners are here. And when we have a live meeting, they have big banners on the walls. And when you see those banners up there and here, you can pretty much bet they are good folks to deal with, because if they don't do us right, because we're so small, boy, that gets around quick. And you don't see them on these banners very long. You don't see their banner on our walls very long. They don't last very long if they're not really good at what they provide. So I love that you can have some confidence when you see them lined up and signed up in our organization and with our world. So check them out, put them on your list. They are also at the bottom of every email that I send out, a way that you can link to their website. You can click on that so you can get more information or connect with them as well. So please do so. We also, at the beginning of any of our meetings, if any of our corporate sponsors are here in the room with us, whether it's Zoom or in person, we give them the opportunity to say hello and maybe what's up. So Joe's going to help me. Any corporate sponsors that are here, please say hi. Frank, I see you.
Here, so.
Yeah, Frank Folco, tell us, say hi and what are you doing and what's up?
Well, I'm sitting at home doing nothing like everybody else, but good evening, everybody. My name is Frank Folco, and my wife and I and my daughter, we run Equity Title here in Lakeland, and we've been doing it for over 19 years. We do closings all throughout the state of Florida, really all over the world if your property is in the state of Florida. And I just want to give you a caution coming up here right now. I guess we got another hurricane or tropical storm brewing. So if you need homeowners insurance, not title insurance, if you need homeowners insurance, make sure you get a binder on it as soon as possible, because once that gets close to land, you're not going to be able to get any homeowners insurance until it's totally gone. So it's really important that you do that. If you'd like to call us, our phone number is 863-802-9300, or you can email Sue or Cindy at equity-title.com. Looking forward to hear you. Be safe, everybody.
And the other thing to know, and Frank, is I want everybody to know for sure, you're not just a corporate sponsor, you're also an investor just like us. And so Frank and Sue invest in all kinds of different things, including some Airbnb and other things. So he's a great resource for you all to ask questions of or connect with. So, and I appreciate you telling us about that storm, Frank. Sometimes we forget about that. Yeah. Thank you so much.
No problem.
Yeah, I think we have Rosemarie.
Okay. Oh, do we? Okay, great. Rosemarie, one of our newer corporate sponsors. Rosemarie, say hello, and what are you doing?
Well, hello, everybody. Thanks for letting me be here today. And I can't believe I actually made it on time. I just came from a closing myself. I am a mobile notary. As you can see, a mobile notary and signing services. So the signing service part is, like I just mentioned, I do mortgage closings. So if you have any real estate agents, any mortgage people, investors, anybody and everybody could ask for me specifically, even if you're told you can't, you could specifically ask for a particular notary. I am bilingual in Spanish. And I just officially now have my platform up and ready for remote notary, which means I can notarize any document, regardless of what it is, anywhere in the world, as long as I'm here in Florida doing it for you. So I do offer that
Wow,
services as
okay.
well. So I'm happy to say that. And and I also do anybody that needs a little bit of help. I'm trying to build a business where we could do remote or a virtual assistant. So I'm trying to build that part of it so I could actually fire my husband from his 9 to 5 and make him independent. So we are doing that. So welcome aboard if you're new. And this is a real fun group, and I look forward to it. I'm kind of addicted, but it's
Well,
a
we like
very
to hear that.
it's a very good group. I really have gotten lots of input and help. And so, yeah, it's a great group, and welcome aboard. Thank you.
I love that. No one could be more tenacious than Rosemarie in starting her new investor world. She is really, really one of those great newbies that absolutely dives in and will just do whatever's necessary. So if you need a good example of that, Rosemarie is a great example of what you should do when you try to get started in real estate. We're glad to have you, Rosemarie.
Well, I've had some great mentors, so I can't take all the credit. But thank you.
You're doing great. Thank you very much. Do we have any other corporate sponsors, Joe, that you can see on there? I'm not sure if.
Yeah, not that I see, but I don't necessarily know everybody. Anybody else out there?
Yeah, please speak up if you're here with us. Okay. If not, then we are on it. Speaking of memberships, I just want to encourage others to join. We have a special pricing right now of only $100 per year. I don't know how long we're doing. We've been doing that during the COVID thing. I'm not sure how long that will continue. It usually is $125 or $150 if you're a couple, but right now it's $100. So please join us and support us in our mission and our goals. We'd love to have you be a part of it. As you can see from what I told you earlier, when you're a member, there's a lot of other meetings that you also can come to. And so we encourage you to do that. All right, Joe, there's our disclaimer. He's ahead of me. I just looked up and saw. There's our disclaimer. Joe, tell us in a capsule. I know they're going to read every word of this, and they should. They absolutely should. But give us your rendition, kind of, Joe, of what this is all about.
Well, I just wanted to give everybody a minute to just soak in the, just that beautiful orange glow so that they felt comfortable with it.
Yes, it makes our lawyers so happy.
It just really says, we will do our best to give you information, accurate information, but it really is up to you to do your due diligence. We don't hold ourselves out to be any type of legal or accounting or any type of, professional advice. We're just here to share information, but please make sure you do your due diligence. And, I think Adrian would say, don't trust anybody. So.
That's right. And don't blame Joe or I tonight. You can't do that. You just can't do it. So that's it. And Andrew, you're an attorney. We probably should be saying this better. Now I'm embarrassed. I forgot we had a real attorney on here. Oh my gosh, I can't believe that. We botched that so bad, Joe. She'll probably get on to us later. Oh my gosh. Okay, so go ahead, Joe.
Hey Liz, we could blame Adrian.
Oh yeah, that's true. He's not here. Excellent.
Exactly.
Okay, I like how you're
him.
thinking, Rosemary.
I got your back, girl.
Thank you. All right, that was our disclaimer for the evening. Just a couple of announcements, and then we're going to get started with Andrea. One announcement that we have is about Pete Fortunato and John Schaub. I don't know if you have that document up, Joe, or not, but we need the document that shows about their upcoming class. This was not one that I knew about until today, actually. It's going to be on Saturday, November 21st. I don't know that this was planned. I think they've just put this together, but I don't know. I mean, it's very exciting because they just put on a big class recently, but this one is going to be a 6-hour Zoom presentation, one day live, and it's called Change is Happening, okay? And I don't know if you all can see that. You can enlarge that if you want to, but here's the bottom line. It says, get ready and make smart decisions. You're going to have 6 hours of time with both Pete Fortunato and John Schaub. If you don't know who those guys are, Google them. They are people near and dear to our heart, some of the greatest teachers that you can have in this generation. I'm telling you, it's amazing what we can learn from them. Get every moment you can from them. This particular class is going to be $295 if you register by November 20th. And it's going to go from, it looks like 11 a.m. to 5 p.m. So that's a nice range right there. And you're also going to get a 100-page workbook that goes along with that. You're going to learn how to acquire property strategically. You're going to seize opportunities that most will miss. You're going to protect assets, lower your profile. You're going to prepare for inflation or deflation. I know everybody's talking about that right now. We won't go into the politics of it, but we don't know what's going to happen. And all the different strategies, okay, that it talks about. So I'm telling you, this is going to be a great evening. You can go to johnschaub.com, and we can put that in the chat a little bit later. I'll try to do that so that you guys can get there easily. And I'm going to send out something in an email too. So we encourage anybody and everybody to go to that if you get a chance, please. Okay, let's get going. Now, as I told you all earlier, and Joe, I think we're ready to start with Andrea's presentation. So,
Okay. So Andrea,
listen,
go ahead and
here's
stop
what I
there.
want.
You take over.
Yeah, there you go. So Joe's going to get that. Well, I'm going to let you know a little bit something about Andrea so that you know who you're going to be listening to tonight. And this is a busy woman, and you're going to know why when I list the things that she's involved in here. So she's an attorney. I've already mentioned that before. And she's part of one of our corporate sponsors, which is Commonwealth Trust Services. And Commonwealth, they're very generous in supporting PCREIA through the years. Augie Bylot and she are partners, and she's a manager also in Commonwealth Trust Services. She's been licensed with the Florida Bar since 1988. So although she looks like a very young lady there in the Zoom thing, she's been doing this law thing since 1988. She's been a business owner also since 1998. And as I mentioned, a partner and manager in Commonwealth Trust Services since 2017. Commonwealth Trust Services serves clients through providing land trust documents, preparation, and trustee services all throughout Florida and even in other states. And I know many of you have properties in other states as well. So Andrea can probably help you with that. As well as doing all this, she's also, as her expertise in real estate law, she's also a real estate investor. So she's one of us, guys. She's experienced in residential, rental, Airbnb properties. She's purchased them to fix and flip. She's done purchasing on option agreements as well. So she's not, you know, someone who's just coming in telling you one side of it. She knows many sides of it because she does the same thing you and I do every day. And on top of that, let me give you one more thing she threw in there. She's a licensed realtor. So on top of that, she passed that difficult Florida realtor license test. And so she's doing great in that. And then, not to leave, you know, things left undone, she's also a Florida Supreme Court mediator, certified in circuit and county court. So it sounds to me like Andrea can pretty much cover our behind on almost anything we might need out there. And on top of that, I personally know that she gives back through missions and charitable giving and service in her community. I know that about her personally. So last and not least, I found out she's a mother of 4 young, confident, successful adult children. Now, that's a big deal. They're young, confident, and successful. It's not easy to get those kids out there in the world and going the right way, and Andrea did it. So she's a well-rounded, great person that we have supporting our organization. And tonight, her focus is going to be on land trust and how to tell us how we can protect ourselves. So please welcome, if you would, Andrea. We welcome you so much here at PCREIA. Thank you for being with us tonight.
Well, thank you, Liz. Now I don't need to say anything about myself now. That was that was very good. So as you can see from my screen, I'm with Commonwealth Trust Services. We're one of your also your sponsors for PCREIA. We have been in business since, I believe, 2014. 14 or 15 when Augie Bylot formed it. I actually, even though I've been an attorney for a lot of years, I never did trust work, but even trust attorneys in the normal trust realm don't know about land trusts. And I had never heard of a land trust until I met Augie. I became a part of his coaching program in 2015 and was about to purchase my first renovation property with a partner who was also in the PACT program. And Augie said, well, you need to do it through a land trust. And that was the first time I really heard about that. So through, of course, through learning through Augie, and over the next couple of year, I guess, in 2016, I became a help with Commonwealth and then joined the team officially in 2017. So it's definitely if you say a well-kept secret, it's not meant to be a secret because it's on the Florida statutes, as we're going to see in just a minute. But a lot of people do not know about it and how it can benefit them.
I think, Andrea, if I can interrupt just real quickly in regards to that, I think it's critical for everybody to really hear that, because you think that attorneys know everything about all types of law. They do not all know about land trusts. I ran into one today. I didn't run into a lawyer, trust me, but I did run into a lady who had done something, and she should have put that property long ago in a land trust, but the attorney who did her thing put it in a life estate and did some other stuff, and all she had to have done in the beginning was put in a land trust. It wasn't that was a bad lawyer. The lawyer just didn't know about land trusts. So I really want to point that out. What you just said is very critical. And the last thing I just want to point out, and then I'll butt out, is I think, Andrea, you mentioned to me that you are fine with people asking questions during, or do you want them to hold their questions to the end?
I'm fine with them asking questions during. I mean, if it's something that I'm going to cover in just a minute or two, then I'll let you know. But yeah, sure. I think we're
okay.
Pretty informal here, which is great. So I welcome questions while you're thinking of them. That's fine.
Yes, that's perfect. And everybody you can put your questions also over in the chat, and Joe and I will be monitoring that, and we will make sure that you get your questions answered before this is over. So if you don't want to interrupt her, that's another way you can do it. You can send them directly to Joe, directly to me, or just put it to everyone, and we will make sure that happens. Okay, Andrea, I'm sorry, but I thought it was important that people know lawyers don't know everything. Okay, right, so you need to have somebody that does, know about land trusts.
Yeah, and along those same lines, I know Augie always says, you know, when you look for a doctor, do you just go to any doctor for your heart or any doctor for, you know, whatever other ailment? You look for somebody who specializes in that type of thing. And I often talk about that at the end of the presentation when we talk about picking the correct partners for us in our business, because a real estate business is different than other kinds of businesses. So, you know, we need to make sure that we're questioning even the title company. Not all title companies understand how to close investor properties, especially with the land trust. So you really need to be specific about that. And even like a mobile notary, the sponsor that was just on, she offers certain kinds of things that other mobile notaries don't offer. So you need to be aware of what kinds of things your partners offer, and are they going to be able to help you in your business. And just this next slide I have up is just a little introduction slide. I think, you know, the reason we're all on this call is because we are trying to use real estate as our vehicle to get us to our goals. We all have goals that revolve around some type of financial freedom, or financial freedom is going to take us to accomplish our goals. I know we all have a lot of different goals at this stage in our life. When I first got involved in real estate investing, I was, you know, looking to finish putting my kids through college, build up my retirement accounts, and just travel more, those kinds of things. I know, like Augie will talk about, his investing goals have changed. He now wants to invest more in other people, spend more time doing ministry and giving back, those types of things. So whatever all of our different individual goals are on here, they all revolve around us becoming more financially free so that we can get to where we want to be. So real estate is a big part of that for all of us. I mean, there are other ways that we can build our financial freedom, and a lot of these things are through our retirement account. Retirement accounts don't just hold investment properties like most of ours do on this call. We also have a lot of retirement accounts, of course, that are involved with stocks and bonds. They may hold other types of things. Perhaps you've got special coins and that type of thing. So that is something that you can amass in private. In other words, you can go on about your living your daily life, and when somebody looks at what you have on the public record, they can't find out what's in your retirement account. They can't find out how much cash you have at Bank of America. So our retirement account and our bank account is private. Shouldn't our real estate holdings also be private? Because that's something that we all on this call are using to build the most amount of our resources for the future. So we don't want to put those in jeopardy by having them be exposed to the public. And a lot of people say, well, what difference does that make if people can see what I own? Well, we live in a very litigious society where, unfortunately, people are looking to gain by not through their own hard work, but by seeing how they can make it easier for them by suing someone else. And I know that all of us have heard those kinds of horror stories, especially people maybe in the landlord realm where you've got tenants that may want to, take advantage of you. And it's not just that they may want to sue you, but if they know that you're the owner of the property that you're leasing, they might want special favors that they wouldn't want if you were just acting as the manager and they didn't know who the owner was. So those kinds of things are things that we want to talk about and are reasons that we want to look at a land trust. Probably the biggest reason is privacy, that most people seek to title the property in the name of a trust. So we're looking to do all sorts of different things. We're wanting to buy single family homes. Maybe we're looking at buying apartment complexes, multifamilies, duplexes, all different things. We also might want to buy vacation properties, Airbnbs. So what if we could keep all of these things private so that no one else could find out about our ownership? Florida statutes provide a simple and an inexpensive solution for this issue. It allows us to hold legal title to real estate or other property interests. They have to be established through something that can be recorded, a recordable instrument, and a written agreement between the trustee and the property owner. So this is a very cool tool that in Florida is actually on the books. So trusts are statutory in several states. These ones I've got up here, I like to indicate what they are because people always ask me what other states are there, and I can never remember. But it was first formed in Illinois, this concept of a land trust, and put on their statutes. And Florida is a very similar creation. Our statutes were patterned after Illinois. So we have Indiana, Virginia, North Dakota, and Hawaii. Now, trusts are valid in all 49 states because they're based on revocable trust law principles. So it's a very similar principle as your living trust that you may have set up right now. You're in control of that trust, typically as your own trustee, and it's revocable. So at any time, you can change the terms of the trust. You can actually close the trust, that type of thing. So that actually is the basis for a land trust as well. There's a settler for the trust, which is you when you want to form one. You're placing your property interest into a trust. You're called the settler of that trust. And once you settle that trust, form it with the trustee relationship, then you are also in control of that trust and can terminate it. Now, Louisiana is a little bit different. It was formed based on French law, their laws. So you cannot form a land trust such as we're going to be talking about tonight. Now, people do call us a lot at Commonwealth Trust Services and ask us if we can be a trustee in other states. Even though a type of land trust is going to be valid in every state because it's based on revocable trust principles, we still have to look at the laws of that state to see if we, as an out-of-state trustee, can serve. And I'm going to get into a little bit more about what our role is as a trustee for land trust under specifically the types of law that Illinois and Florida set forth. I'm going to see. So there are basically three mandatory elements to making a land trust valid. There's only 2 documents that you have to have, and that's the deed to trustee. So there has to be a grantor actually granting the deed to the trustee, just like in any other normal transaction. When you purchase a property, you've got your seller that's the grantor and basically assigning the rights to the property to you through a deed. So that also has to occur because somehow the trustee has to be vested with ownership to this property. Now, in that deed, there has to be specific powers granted to the trustee, which is basically that they have all the power to sell, transfer, dispose of, manage that property. And then the second thing in writing that there needs to be is a written agreement between the trustee and the beneficial owner. And that's the part, because people always ask me, well, that's kind of scary that I'm going to be deeding my property to you and you're going to have the full power over that property. And that's correct, except under the statute, there's this written trust agreement that is required between the trustee and the beneficiary, and that gives all the power back to the beneficiary. It's a contract, if you will, between these 2 parties that's going to give the power of direction to the real owner that's private, which is the beneficiary. Now, to the public, the trustee is the owner, the equitable and the legal owner of the property. So the public ownership vests in the trustee for the benefit of the beneficial owner, which is the beneficiary or perhaps a group of beneficiaries. And we'll talk about that in a minute. So the trustee owns the real estate in its fiduciary capacity. And what fiduciary means, it's just like a fancy legal word for saying that the trustee has a special trust under the law that they have agreed to do certain things that they're obligated to do through this contract. And when they sign a contract, then they have certain responsibilities and they can be sued and judgments against them if they didn't act in accordance with that contract. And we'll talk about that a little bit too, about how important it is to choose a trustee that is going to abide by those fiduciary duties and also is aware of those fiduciary duties. So the beneficiary is retaining complete power of direction through that land trust agreement. And now they can grant the power of direction to another person or entity. And we'll talk about when that comes about. Typically, I would say 95% of the trust that we have at Commonwealth, the beneficiary is the director of the trust. And they don't even have to specifically be set out as the director. They are the director unless they tell us in writing that someone else is going to be directing their trust. And that's typically or out of commission for a while, and they're going to let somebody else manage their trust property. So a trust is not a legal entity. It does not have a taxpayer ID. The way that the trust property is taxed is the same way that the beneficiary is taxed. So depending on how you hold your beneficial interest, I may have already mentioned that I have properties in my retirement account. Well, those are also owned in trust. So those particular properties would be taxed however that retirement account is taxed. So some of you may own properties in your own name, or you may own them in an LLC or in some kind of a partnership. So the tax responsibility is going to flow through the trust to however you would normally file taxes with regard to that property.
Andrea, we have a couple of questions that have popped in.
Okay.
A little bit, I think, related to something you covered just a few minutes ago. Roxanne asked, can specific powers be put in a memorandum of trust rather than the deed itself?
Well, the specific powers that are required to go in the deed. In Florida, that's actually statutory, that there are specific powers that have to go into the deed in order to make the land trust valid. And you think about it, it makes sense. If we don't, as a land trust trustee, if we don't have the absolute power to grant, sell, convey, transfer the property, then when we go to, say you've got a property that you've placed in trust and now you want to sell it out of trust, when we go to sell that property and sign that deed, if we don't have that power, then the trust has to be what you call bared, which means we'd have to show the trust document, which the title company would probably want to record to show that the beneficiary is agreeing, and the beneficiary would also have to sign the deed. So there are trusts out there. In fact, most living trusts that people have for estate planning purposes, that's the way they're set up. Typically in your living trust, you're going to be the trustee of your own property, and you're going to be signing off on everything that is required. If sometimes there'll be one person who's the trustee for maybe a family trust, and the beneficiaries are all involved in that trust, so they may also be required to sign the deed or sign something that's recorded saying that they give permission to do that. So in a land trust, we don't want to do that, because the primary benefit, the primary thing we're trying to do is to keep our assets private. So in that case, the trustee has to have all the power on public record.
Great. I think the next one is just more of a clarification, and that's, can the trustee sell the property without owner's consent?
So the trustee cannot, because they are bound through the land trust agreement. They can only take any substantive action on the property by contract. They can only take a substantive action on the property with written direction. So what we require at Commonwealth is, we are signing sales packets all the time, purchase packets as well. Before we sign those documents, we require an email from our client. Now, remember, this client's already set up a trust, or we wouldn't have a trust in the first place. So we already have a communication going back and forth with them. They've already consented to have a trust set up. They've ordered that trust. Now we reach out to them, typically an email, once in a while, depending on the circumstances. We will ask for a formal direction that's notarized. That's not the norm for a sale packet, because we're working closely with the beneficiary on a day-to-day basis when that's going on. But we do require something in the form of an email to say, yes, we approve these documents, please sign them. So I guess logistically, could a trustee actually sign on the dotted line without permission? Sure, they could. I mean, that would be an actionable against them by the beneficiary if that wasn't approved of. But legally, we are bound through the trust agreement not to do that. That's another reason that you want to, be careful with who you choose as trustees. Historically, we've had people come to us who have, maybe a past girlfriend or a family member who really know what they're doing. They wanted them to be their trustee, and now they're having difficulty with that person because either they don't understand that they're not supposed to be telling everyone who the real property owner is, and they don't know that they have a fiduciary responsibility to not act on that property. That property is not really theirs. They're holding it in trust. So you do want to be careful with making sure that people that you involve as your partners in a land trust, especially in the way of your trustee, understands these rights and obligations under the law.
It sounds like if they breach that trust document, then you'd have to litigate, which ties up money,
Exactly.
ties up time, and so that's the key for picking somebody you trust.
Exactly. Yes.
The next two questions look like they deal with setting up land trusts.
And I'm going to get to that in just a few minutes on the
Okay.
setup part.
Okay, I thought you might, so we'll
So
hold
we
those
could
till then.
maybe hold off on that. Maybe hold off on that one, and if I don't answer the question, then I'll come back to that.
Great.
Okay, so I know I mentioned that a land trust is a specific, unique type of trust, and you have to have a recordable property interest goes into it. So it can be a deed, a mortgage, certain notes, options, leases. You can't, we get questions a lot of time, well, can I put my, also put my coins in the trust, or put, some other type of asset in the trust? And that's not permissible through the statute. It has to be only a recordable instrument. So we've talked a little bit about the privacy already. There's not going to be any public record of the beneficiary's ownership of the property. And I like to show this slide because it indicates exactly what it will look like when someone looks at your property that's held in trust by us. So because we're a corporate trustee, we have lots of properties all over the state of Florida, a few outside the state of Florida. But when you go to especially Central Florida property appraiser website and you pull up a property that's held in trust by Commonwealth Trust Services, you are not going to be able to link that to any specific person, because they're all going to come up here generically. And that brings me to another fact that we always recommend, that when choosing a name for your trust, you keep it unique, but pretty general at the same time. Unique in that we like to use the property address. That's easy for us as a corporate trustee with about 400 trusts to be able to tie mail that we get to the specific trust property. But it's also helpful because probably I know about 90% of people in the state of Florida that set up a land trust use the property address. So even though it's unique, no one else is going to have that property address. So your trust is unique. It still kind of looks like everybody else's in the state. We have had people come to us and say, well, we want to name all of our trusts like Smith Trust 1, Smith Trust 2, Smith Trust 3. Well, that kind of joins those properties together. I mean, maybe their name's not even Smith, but if somebody searches in a county and properties pop up with the similar name like that, somebody might think, okay, I've had an accident, or I live at this property that's titled Smith Trust 1. I go to the attorney looks up the ownership. He says, well, let's see what else we can find out. And he finds out that there's 10 other trusts, Smith Trust 2, Trust 3, Trust 4. He's going to put 2 and 2 together and say, okay, well, this beneficiary has some assets. So yeah, I'll go ahead and I'll represent you, because we can tell they have assets. But when they look up and they just find out it's the 123 Main Street Trust, and it doesn't look any different than hundreds of other trusts in the county that also have the property address as the title to the trust, then they're going to be a little more hesitant to want to take that case, perhaps, because they can't really tell what the beneficiary's assets may be or what other properties are linked to that beneficiary. There's just another example. I think that last one was perhaps, let's see, yeah, Volusia, and here's Seminole County. So you can see how they pop up and what it looks like on public record. Another big protection that we like to talk about is lien and judgment protection. When your property is held in trust, and say, as we're building our real estate business, amassing multiple properties, life is also going on in our personal lives. So perhaps we're involved personally in some kind of a lawsuit. Perhaps there's a personal judgment against us, that type of thing. Well, that personal judgment is not going to attach to any properties you hold in trust. That also becomes very important when you're doing partnerships. A lot of us partner with other people on our investment properties. I know I almost always have a partner when I do, especially renovations. I have a partner on my Airbnb property, and I've had several rentals with partners. And you want to make sure that your property is also protected against maybe life that's going on with your partner. If your names are both on that deed on public record and they have a judgment against them, that's going to attach to your trust, to your property, but not when it's held in trust, because the beneficiaries are private. So that property can go ahead and be sold and proceeds distributed, even though there may be a personal lien or judgment against you. Now, the same goes for the trust property. You know, a lot of us, you know, we have tenants, things may happen on our property, we may get sued, there may be a judgment against that property, there may be a code lien against that property. And say you're trying to sell one of your other properties when there's a code lien against a different rental. You know how that can cause a problem when you go to sell it if it's titled in the same LLC or the same individual. They're going to want to collect on those code liens before they let you, you know, sell the property that you're in the midst of selling. So the other property is going to hamper that. So that's a really important benefit. So the beneficiary can sell his beneficial interest even with a certified judgment against his or her name in the public record. This also applies to IRS liens as well. Now we've talked a little bit about avoiding litigation. Property owners, we're all easy targets for lawsuits. If a person doesn't look like he has any assets, a lawyer may not take the case. I know Augie always says that when he was younger, he couldn't wait to, you know, advertise that he was doing better in the world. He was successful. He had money. He had a nicer house. He had you know, cars and that type of thing. But as he gets older, he wants to make sure that all of those things that may show that you're affluent, those things are tucked away and kept private. So I know, you know, we've heard of that book, The Millionaire Next Door. That's the kind of person you want to be. You want to be the kind of person that people don't know is the millionaire next door. So your asset
You want to keep
protection.
those millions, right?
Pardon?
I said you want to keep those millions, right?
That's right. That's right. So you want your asset protection plan to keep your name off of property records.
Why the volume gone now?
I didn't catch that.
I think somebody may have just been unmuted, so if you please check,
Oh, okay.
check your
Okay.
mics and mute if you're not asking a question, please.
So when we talk about your asset protection plan, a land trust is one of the tools that we're going to use. It's going to add to your asset protection plan. It's not the ultimate asset protection plan. People always ask me, oh, does that mean that, you know, I can get sued and it won't affect me? Well, absolutely not. I mean, the beneficiaries of a land trust can be revealed through court order. So if for some unfortunate reason you were sued on a specific property and the judgment came through and it was over and above your insurance limits on that property, which insurance is a very important tool also that you're going to want to use for asset protection, then the court may order to bear the trust and find out, okay, who is the beneficiary of this trust and what kind of assets do they have. So it becomes important as to how you hold your beneficial interest. That's when you may want to look into holding certain properties in an LLC or maybe forming a corporation, that type of thing. So a land trust is not insulation from lawsuits. And if it's a lawsuit for negligence, of course, then you could get a judgment and you could actually have to go ahead and over and above the proceeds, or I'm sorry, the insurance benefits that you may have to cough up some bucks. So you want to make sure how you're going to be protected. There's something else I was going to say about that. Let's see. So we were talking about, yes. Yeah, so LLC is important. Perhaps a corporation. Oh, I know what I was going to talk about. And holding your properties, you may have buy and holds. You may have also do flip properties. So you may want to have more than one LLC. And I know any good accountant is going to tell you not to hold over a certain amount, perhaps maybe $500,000 of properties in one LLC. So once you're going along and you're getting maybe 10, 15 rental properties, you might want to have several different LLCs that you are titling those properties in. And of course, that's also going to help your accountant with your characterization of income, because remember, when you're doing fix and flips, those are going to be taxed differently than when you have passive income through rental properties. So those are all things you want to think about as well when you're setting up your trust, choosing who's going to be the beneficiary of your trust. Partition actions are prohibited in trust. And now a few minutes ago, I talked about, you don't want to have your partnership on a deed with another partner, because then that property is also exposed to everything that's going on in their life with regard to lawsuits and judgments and that type of thing. Well, you're also exposed to partition action when you have a property jointly with a partner or several partners. Things change in our lives. We enter into an investment property and we're all gung-ho to keep it for rental for maybe 5, 10, 15, 20 years. And all of a sudden your partner comes up one day, maybe 2 or 3 years into it, and says, you know what, I really need the cash. I need to sell this property. Well, when you're both on the deed, there's nothing to stop them from filing suit and asking it to be partitioned, that property. And realistically, we know that the only way to partition a property is to sell it and partition the proceeds. You can't really cut a property in half. So with a land trust, that is not possible. Partitions are prohibited. So the only way that partner could get cash for their portion of the property would be to sell their beneficial interest, which they could do. And we might have a slide that talks about it later, but when you enter into a investment in a land trust with a partner, you'd probably want to put in place something called a beneficiaries agreement, which is very similar to like a joint venture agreement, where you kind of set out your rights and responsibilities. And that's a good place to put in a first right of refusal. Perhaps you want to make sure that if your partner does need to sell at some point, you have the first right of refusal. You may want to set out some boundaries for how they'll be able to sell that property, or maybe to who. So there you go. It's going to provide, because of that, more secure partnerships and joint venture opportunities. It's going to make you feel a little bit better in your partnerships, because it's not going to be exposed to the public. I know a lot of us, I know there's other people on this call that I'm familiar with, and I know they do, deals with a lot of different partners. So do I. So you might not want to be advertising that to the whole world, who your different partners are, and also the different percentages, because unless you're holding the trust or the real estate investment property equally, which you would be tenants in common. If you're not holding it equally, sometimes we're 60% partner and our partners, got less than 50%. We would want to make sure that that's documented. So in order for that to be documented on a deed, you'd have to actually spell out the percentage. So it's a lot nicer to have that privately documented in the land trust agreement.
Andrea?
Yes.
Considering you mentioned a couple of times about structures of setting this up, there's a couple of questions that have come in from Hemet. I hope I pronounced your name correctly. And if you'd like to chime in and ask the question, you're welcome to. Otherwise, he's asking, as a sole owner of an LLC, may transfer it to a land trust and become the trustee himself. And then he
transfer it to the?
Go ahead.
Is he asking if he can transfer it to a land trust and become the trustee himself?
Yeah, can I, a sole owner of an LLC, transfer it to a land trust and become the trustee myself?
Yes, you could actually deed it to a trust. When you deed your own property to trust for estate planning purposes, and the deeding of it does not change the structure of your ownership, the underlying structure. In other words, you're not deeding it into trust and having a partner in the trust. That would trigger doc stamps, because that's a change of control. But when you're just deeding your own property into trust, you can certainly do that. Now, I'm going to talk a little bit more about it later, but when you become your own trustee, you're giving up one of the biggest benefits, which is privacy. So you'd want to think twice about doing that. But you can certainly do exactly what he questioned. Yes.
Yeah, it seemed to me it fit a little bit in avoiding litigation, just because, again, of the privacy portion of that.
Mhm.
Steve did ask, actually haven't had a follow on it. So he said, can many properties be simultaneously transferred from LLC to one trust?
Yes. You can do that. We recommend that you place each property in a separate trust, simply because you lose the lien and judgment protection. Say if you've got, one or two or three or four or five properties in one trust, something happens and there's, say there's a code lien. We've had this happen before where there's a code lien against one of our clients' trusts in their LLC. They're trying to sell their other property. They can't do it until they clean that code lien up. And that can come in at the most inopportune moment, right before a closing. So that's something that you give up when you transfer multiple properties to one trust.
And that's a case where when you have that type of a lien, it attaches to all your properties that are associated with that.
Exactly.
Okay.
Yes, because they're all titled the same.
Mhm.
Just like if you held it in your LLC or in your own name, when they have the same title, those judgments are going to go against that title. If it's against you as an individual, if it's against your LLC, it's going to affect everything that's held that way.
And Steve asked, and I'm going to slip this question in here too. Steve asked, and I think it does fit in with the litigation. Could you create your own land trust, or should you have it professionally done? He says he gets pushback from realtors to have details on the trust.
Mm-hmm.
And he believes that's because they don't understand it. And that's probably true.
That's very true. Yes. So you can create your own trust. Actually, Florida statutes, it's you can look it up and on the books. I had cited it earlier. It's very simple to read. Maybe not as simple to understand if you're not familiar with the terms, but it's not very long. There are certain things that are required in the land trust in order to make it a valid trust. Now, our trust is about 5 pages long, and most other trusts I've seen created by attorneys and trust companies are about the same. So, I mean, it would probably be my recommendation that you at least pay for your first trust to be created. And if you're going to use a corporate trustee or professional trustee, which we also recommend, because that way, especially if you use a professional trustee that's in the business of doing that, your trusts then become one of hundreds of trusts instead of just one of 5 or 6 trusts that have you or your, whoever you've chosen to be your trustee. So it makes them look even more anonymous.
So, Andrea, the reason I put that question in here is because if we set those trusts up incorrectly, does that invalidate the trust? Does it allow an enterprising lawyer to be able to pierce the protection that you get from a trust easier if you don't do it correctly?
Yes. Yeah. Well, yes. The privacy part of it I'm trying to think, for a lawsuit, how far you'd have to go down the line. I mean, they are probably not going to be able to see your trust agreement. If they are going to be able to see your trust agreement, the names would be redacted at that point in order to see if it's a valid trust. So typically what we do is a lot of title companies actually that don't understand land trusts want to see our documents. We resist that. And typically we give them a certification of trust, where we, swear that under oath that this trust was set up under the statutes correctly. It's been a valid trust. There's a litany of things that have to be stated. So the problem with being your own trustee is you really have to be familiar with how to do that and how to deal with the inquiries and how to have those kinds of documents. When you say invalidate the trust, I mean, when it's I don't know how far down the line they would get, when they would actually see your trust agreement, if you were able to provide a trust certification of trust affidavit. So if you provided that, then, chances are you're going to be good for a little while. And when it gets down to the end, if you've have a lawsuit against that trust property and then there's some kind of a judgment, I mean, if there's insurance, that's what they're after, and the insurance covers the judgment, then you're not going to have to bear the trust. It's only if the insurance didn't cover the amount of the judgment that then the court would probably have the trust bear it anyway. And then it really doesn't matter if it's valid or not because the beneficiary is revealed.
Okay, thank you.
Also, Andrea, I noticed, speaking of this privacy issue, Walter Bartholomew, who's a very wise investor in our group. Walter, you made a comment over in the chat earlier. If you can hear me, can you unmute and tell us what you meant when you said something about the property address being used in the land trust name? Walter, can you hear me? He may not be able to hear me. So I'll tell you what his comment was. And Walter, if you want to interrupt me, please, so you can explain to Andrea and us a little more. He says that he doesn't support using the property address for the land trust name because there can be information leaks which might minimize privacy. Do you have an idea, Andrea, of what he means by that?
I don't know unless I'm not sure unless he's talking about like when you the property appraiser, if you're going down, if you're dealing with the property appraiser on your property, and they're not going to guarantee your privacy if you're disclosing to them, you know, that you're associated with that particular property address and that type of thing. If that's maybe what he means, I'm not sure. Maybe. Okay. Yeah.
Do you always name the land trust after properties, or do you? It just depends on.
I mean, it depends on what our beneficiaries in control. They order the trust and they order the name. Typically, they will ask us what we recommend, and we tell them that we recommend the property address. And it's usually just 1, 2. We've even stopped trying to stop using street, avenue, those kinds of things because it makes the trust name so long. But our trusts are always vested first in us as trustee. So it's always Commonwealth Trust Services as trustee of the, 123 Main Street Land Trust. That's why when those slides I showed you a little while ago, when you see all those properties, it comes up with Commonwealth Trust Services. You don't even see the name of the trust. And the reason that we do that is because years ago, when Commonwealth Trust Services first started, they used the property address first, the 123 Main Street Land Trust, Commonwealth Trust Services as trustee. But it became a problem with documents because people were always putting the address, they were shortening everything because you can't fit all of that. So it ended up being the 123 Main Street and Land Trust. And then we were signing it and there was like, where's the connection there? Where's the connection with you as Commonwealth? Or we would get checks from insurance companies. They would make it out to the 123 Main Street Land Trust. Well, guess what? We don't have bank accounts for the 123 Main Street Land Trust. We have bank accounts for Commonwealth Trust Services as trustee. So the property has to be vested in a person or entity that can sign. The 123 Main Street Land Trust alone cannot be the title owner because then the trust would have to be bared because there's no person or entity indicated as trustee who can sign, who can be the grantor, who can be the signer on documents, if that makes sense. So we've started putting our name first several years ago, and most other trustees also do the same thing.
Walter doesn't have a mic, but I think what he's saying is if you're trying to keep your property, and your land trust and that, if you're trying to keep it secret, if you put the address in the name, there he goes. There you go.
Oh, she's saying look over in the chat area. Walter is able to type more over there.
Oh, okay.
Yeah. So what he's saying there, Andrea, is I do support using the house number as part of identification if you want, just not the street name. But a good aggressive paralegal can research property appraiser, court clerk, postal carrier, and the neighbors as sources of information that would put a crack in the privacy wall. How big a crack does a termite need to get in?
Okay. Well, right. But typically the only reason they're going to come across the name of the trust is when they're looking at the property. You look up typically somebody's going to a lawyer because this particular property is a problem for them in some way. Maybe they were injured on that property, whatever. So they're looking that up, and they're seeing it's called the 1, 2, 3, 4 land trust. So whatever, if you just use the street name. So I haven't seen that be an issue, because the different properties you own are not connected. They're still not going to be able to see, oh, okay, well, let's see if this property is now connected to other properties. How are they going to connect random addresses together unless you own the whole street, you know? So then, yeah, I could see where it could be a problem. You know, you start talking to neighbors, and they're like, oh, Fred, yeah, well, he manages this one and he manages this one, and they're all titled, you know, similarly. Then yeah, that might be.
Yeah, good point. Very good point. Now, you mentioned insurance. I'm sorry, you mentioned insurance earlier, and that's a big one because Lenny and Ann asked this question over here. It said, who should be the primary insured for a property in trust? Who should be additional insured?
Right, the trustee. Yeah, the trustee needs to be the primary insured because the insurance runs with the deed. So it would be like for us, it's Commonwealth Trust Services as trustee of the, et cetera. When you have a corporate trustee, you don't have to, most lenders, of course, want to be an additional insured. But the beneficiary doesn't need to be an additional insured. They can if they want, but the check is going to get written out to us as trustee. It's going to go into our trust account and written directly out to as soon as it clears, written directly out to our beneficiary. So our beneficiaries don't have to have themselves as an additional insured unless they want to, because a lot of them have a lender that's their additional insured.
Now, Ann, I think, is on here. Lenny and Ann. Ann, if that didn't answer your question, please speak up, because that's what Andrea is here for tonight. If you can hear me.
I have a slide later, I think, where we talk about insurance a little bit too.
Oh, good. Yeah, because one question we get often, and maybe you're going to answer it, is, okay, so Commonwealth is listed on there. Now, when I go to get insurance on a new company and I'm going to use Commonwealth as my trustee, when the insurance company looks it up, they're going to see that Commonwealth has 5,000 properties or 5,000 insured properties or something. Does that affect the insurance cost in any way? I mean, I don't know the answer to that. I know several people have told me different things about that.
We have never heard that has, because the insurance, the insurance companies, not every insurance company is going to insure a land trust. And that's just because they don't understand them. But the ones that do, right, they understand that they're different beneficiaries. And typically it's the beneficiary that is actually dealing with the insurance, setting it up, not us. They're sending it to us to sign, but the insurance understands that it's not, you know, it's held in trust for the benefit of this other person or entity. So we have not had that perhaps ever be an issue.
That may need to be explained to whatever insurance agent is helping you, because if you have a lot of claims, obviously, then that becomes an issue under normal circumstances. So they need to know that that is just a trust company and be reminded of that, perhaps.
Yeah.
Okay.
Yeah.
Okay, very good.
From your personal experience, did they use your federal ID of your LLC when you got your insurance, or do you recall, or did they just use the information of the federal ID? Because you do have to have, when you have insurance, someone has to provide either a social security number or federal ID when you get insurance.
They use your information, not ours. We are
the beneficiary you're talking about?
Yeah, they use the beneficiary information, not the trustee.
Gotcha.
We are non-taxable entity. So all tax information, all tax ID numbers used for the trust property will be yours. Now that brings up, obviously, people ask us, well, what about the privacy? Then, you know, the insurance people know who we are. Well, you're not trying to, the privacy is not to keep it away from your partners you're going to use to help your business. It's to keep it away from the public. The public can't go to the insurance company and type in and figure out, see private documents about your insurance. So you're not really trying to protect yourself against those types of people. Those are the people that are helping you in your business, if that makes sense.
Thank you.
This is just a little example.
I had a question.
Okay.
You mentioned earlier, and I kind of asked it in the chat, but so let's say a person, and I'm totally new to this. Let's say a person has 20 properties. You were mentioning about putting them in LLC. Would you get a different LLC for each property?
No. Well, first of all, I would talk to your accountant about what your needs are. They're going to be able to help you structure, what kinds of properties you have, what kinds of income you're getting on those properties, if they're leveraged, all those things come into play. But typically what I've heard from, my accountant and others is you probably don't want to have more than $500,000 in assets in one LLC. So you'd maybe want to divide your properties up in that maybe you have 2 or 3 or 4 rental properties, depending on the value of your rental properties, in one LLC. So that, in other words, that LLC would be the beneficiary of maybe 4 trust properties. But the advantage of, I know a lot of people recommend, let's put them each in a separate LLC, because then you would have lien and judgment protection with those LLCs, but you also have a lot more expense. You've got accounting for each one of those LLCs. You've got a K-1 each year. You've got LLC, fees with the Division of Corporations every year. So using a land trust instead to title your property and have the beneficiary be the LLC, maybe on 4 different trusts, gives you that lien and judgment protection, but yet doesn't separate them all with a lot of additional LLC costs.
Now, on the second question to this as well is, can you have a foreign LLC? Let's just say that you have an LLC, let's say California, to have you have that property with a California LLC. Is that acceptable? Is that something that could be done?
Yes, we have properties that are LLCs from different states. However, there's still things you have to do if you're going to operate business in Florida, through the Division of Corporations, right? If you've got a property in Florida and you're using it as California LLC, still certain things you've got to do to make that legal.
Yeah, which is the foreign incorporation part that you have to basically register that
Exactly.
LLC out of that state here into Florida. Gotcha.
Right. So you can't skip that, in other words.
Okay, but that still gives you an added layer of protection, so to speak.
Yeah, we have plenty of clients that use, out of state LLCs, Delaware, Utah, or whatever.
Okay, cool beans. Thank you much.
So this is just a little example about litigation. So a man is walking his dog on Lake Ring Road. Sidewalk is uneven and crooked. You are deceitful falls between number 1 and number 2 Lake Ring Road and breaks his neck. Who does he sue? Well, he goes and sits down with an attorney, and an attorney looks up the address of the 1 Lake Road and finds out that, I can't see this is blocking my thing, that Robert Bisrot owns 1 Lake Ring Road. And then he looks up Robert Bisrot and finds out that Robert Bisrot also owns all of these other properties. He looks up 2 Lake Ring Road and finds out that your trustee owns that. And he can't connect the trustee with any other properties because they all have unique names. So in this particular instance, who do you think they're going to sue? Of course, they're going to go for the one with the person that has the most visible assets on public record.
Robert Bisrot is in trouble.
Yeah, exactly. Exactly. I don't know why sometimes my doesn't want to advance. I'm not sure what there we go. Okay. Another great benefit of a land trust is that it makes transferring property easy. The statute is set up and intended for when you place your property into trust. If your trust is written correctly, your property is then going to be personal property. So when you have personal property, you can transfer personal property without having two witnesses in a deed, like with real estate. So your beneficial interest can actually be assigned to someone else with just your signature. So that makes it easy and less expensive to transfer property that way. It's also nice because if you've purchased a trust property, you've got title insurance in the name of the trust if you purchased it into trust, because the trust is the legal owner. So that's how the title policy is going to read at the outset. Now, say you're going along and you really want cash, and you're talking to another investor who is willing to buy that trust property and would like to go ahead and keep the benefits in the trust. So now you've purchased it in trust. So you've protected your privacy because your name hasn't been on public record. And now this second investor is going to take advantage of that. You're going to actually transfer him the beneficial interest, and his name is not going to be on public record. And additionally, he doesn't need a new title policy because the title owner of the property is not changing. It's still going to be the trustee. The only thing that's changing is the underlying ownership. Now, you still may want to have a title search to make sure, maybe the investor you're buying it from has owned this property for several years. So maybe you'd want to make sure that there hasn't been anything that's cropped up since then against the title. But if you do a simple title search, and you can have a closing with less documents than normal, and simply assign the beneficial interest to a new end owner. So it makes it easy that way and less expensive. Additionally, heirs can avoid probate if they're named as successor beneficiaries in the land trust. As we know, probate's very expensive. A lot of times there's things that have to be sorted out on an estate before the properties can vest in the new beneficiaries. In the new owners. So with naming a successor beneficiary directly in your trust agreement, when something happens to that owner, then aside from what's going on in the probate, you can become the new beneficiary of that trust immediately and start dealing with that property, directing the trustee. Maybe it's a rental property, you're dealing with transfer of lessees, that type of thing. So it makes it very convenient rather than having to go through a full-blown probate for that property. Another benefit that's not always used, can't always be used, but often is you can keep your purchase price private. I know a lot of us investors, we're trying to deal, directly with our sellers. So we're marketing directly to sellers, trying to maybe not use realtors, at least not go to listed properties. This is going to be hard to do if it's a listed property, because when there's a listed property, you've already got a barrier between you and that seller. Typically it's a realtor, and if you're using a realtor, then you've got people in the middle, so it might not be as easy. But if you have rapport with your seller, and the seller agrees to place the property in the trust, because the transferring document into the trust is a deed. And remember, we talked about that you can place your own property into trust for estate planning purposes. So the seller can place the property into trust. When he does that, there's no doc stamps due. As we know, the only way that the price of property, the sale price, gets recorded is because the county is the receptacle for the deeds and the doc stamps. And they take those doc stamps, they look at those doc stamps, and they figure out what the sale price is, and they record that. You can actually avoid that step by the deed. Obviously, the deed will still go to the county, but it will go to the county as a transfer of someone's property in there with nominal doc stamps of 70 cents on $10 charge or whatever it is. Then the actual transferring document will be the assignment of beneficial interest, like we talked about a few minutes ago. Of the two investors, one investor is going to sell his property to another investor, and all he has to do is assign the beneficial interest. When he does that, that's an unrecorded document. that's not recorded at the county level. Now, dock stamps are still paid. Don't get me wrong. You cannot avoid dock stamps by placing your property or transferring your property in a land trust, because that's illegal. But what happens is you actually send the dock stamps to the Department of Revenue. You skip the county because you're doing an unrecorded transfer, and they go on to the Department of Revenue with a special form that's called a DR 228. We might have a copy of that form later in this presentation. I'm not sure, but that's how that works. So the purchase price is never recorded at the county level. So the seller's placing it in trust with a deed. Then the transferring document is the assignment of beneficial interest, which is unrecorded. So the seller
I have
is
a
assigning.
question about that specifically.
Mhm.
What name do you put on the DR 228 where it says, I struggle with that, because the whole idea is to keep everything private, and who actually sees that? Let me get one over here.
The DR 228, whose name goes on that.
Because when you fill that out, have you ever filled one out? Because when you fill it out, you have to put in there, you have to put taxpayer, the street address. When you fill that out, when you send it in, those of you who haven't seen it, you submit the money, and it basically says your dock stamps, and you put the amount that you're in for your dock stamps. Then you have to put the taxpayer's name. And my
Yes.
struggle is if you don't put the correct name, if you are ever audited. So what name are you putting in there? Are you putting the name on the deed? Are you putting the name of the beneficial interest?
The beneficiary, because it's
So if
going
you
by
do that-
it's going by the unrecorded document. So the beneficiary's name goes down there and their tax ID number, and it should be the seller, because the seller's responsible for paying the dock stamps. So it's not a recorded document, and the DR 228 is not recorded either. So there's no way for someone to contact the Department of Revenue to see if they'll go through their records and give them a DR 228 on that property. That's not going to happen.
Okay.
So the seller is on that part, and so the new owner of the beneficial interest is not on there anywhere? I don't
Correct.
have one of those in front of me. Okay.
Correct.
So Susan, your privacy is still there as the beneficial interest owner. The seller, though, is the only one that goes on there. Right, Andrea?
But even the seller being
Okay.
on there, that document's not recorded anywhere. It might be in the archives of the Department of Revenue in Tallahassee.
That's what
but
I'm
there's-
saying. Because it actually, it goes to the state. Let me see, I have one right here in
Goes
front
to
of
the
me.
Department of Revenue.
Yeah, it does.
Yep. Yes, because when we have occasionally, we have clients that do an assignment of beneficial interest. So then I do they might have a title search done by a title company, but unless they're purchasing a title policy, the title company is not going to close that transaction. So I'll do the documents. It's a minimal amount of documents, and we will send in the DR 228 from our office to the Department of Revenue.
Okay.
Andrea, while we're talking about, thank you, Susan, for that question. That was a great question. Andrea, while we're talking about buying and selling here on the properties, Hemant Kumar asked a question from a realtor standpoint. Hemant, can you hear me? Are you able to ask this question yourself from the viewpoint of a realtor? Hemant? No, he may not be able to. So his question is, if he lists a property, okay, which is currently under a land trust, if the owner, who is not the trustee, approaches him to list it, who is supposed to be signing that contract? Is it the trustee or is it the actual owner of beneficial interest?
Okay, that is a great question, because we have
Very good question.
so many people that they place their properties into trust, and then they go off and they're selling their property, and all of a sudden, 2 days before the property is going to be sold, we get a title company contacting us saying, hey, we have a closing on this tomorrow, and we're really confused because you're coming up as the title owner and we've done all this work. And so yes, the title owner needs to be signing the listing agreement, the sales documents, the purchase and sale agreement. Now we're only going to sign those things when our beneficiary gives us instructions to do that. So what I recommend is, we have a lot of clients that use realtors, and I think that's great. I mean, I'm a realtor as well. So what we recommend though is when you as the realtor send us those documents, you copy the beneficiary and you say, hey, here's the listing agreement, et cetera. So-and-so has instructed me to list this property. Please execute this. And when that happens, we can easily, reply and say, okay, John beneficiary, we've received this, please approve it. That way, we sign all of those documents, but we need to be the ones signing that. Now, the listing agreement is not going to be public, but the seller's disclosure and the HOA disclosures, any of those things that you're going to attach to listing are going to be out there for the public to see. And most of the investors that we work with, they're doing flips on a regular basis. They don't want people knowing that they're the owners of those properties. So that does become important if that the title owner sign those. And that's the way it's supposed to be anyway with a listing agreement, is the title owner is supposed to be signing. Once in a while on a listing agreement, the beneficiary will go ahead and initial every page, which is great. That way we know they've already seen it, they've approved of it, and we will, we'll sign that for them. But for the disclosures, you want to make sure that just the title owner is signing it so they can keep their privacy.
That was a great question from Hammett, and he just chatted over here and said that he doesn't have a mic or he would speak up. So thank you for the answer on that. I think that many of us didn't know the answer to that question, so I'm so glad that was asked. No, very good.
It's a very, very common question. It probably comes up every week with us. Yes. And it makes sense because they're, the beneficiaries are out there as the managers of their property. They're doing everything on the property. We don't manage. We don't do anything. That's not our role. So then they go ahead and they list the property, which is their right to do, but they just forget that step that technically they don't even have a binding contract unless the title owner has signed that contract. So we need to be contacted and signing those.
Just one quick question. Let's say that, because you just clarified this, let's say we did the DR 228 wrong. How would you suggest that we fix that?
Just to clarify, right, Susan?
Not that you did it, right, Susan?
You're asking for a friend.
When you say you did it, when you say you did it wrong, how do you mean you did it wrong?
Well, like we put
or
the wrong
whoever
name.
did it wrong.
Whoever did it wrong.
No, but I mean, what's wrong about it? What's wrong?
Taxpayer name.
You know what? That's not a big deal. I wouldn't worry about having to correct that. I mean, you want to keep that for your records to prove that doc stamps have been paid. Even if you put the beneficiary, I mean, like we just had a closing recently where the buyer actually was the one that paid the doc stamps. We still put the seller's name on there, but the main thing is to be able to prove that the doc stamps were paid. The Department of Revenue, that's what they're interested in. They don't care who paid what, just so it got paid. So, I mean, sometimes seller pays all the costs, sometimes the buyer does.
Now, I did run across one where sometimes if I buy properties from newbies and they don't know any better, let's say they didn't know they need to pay them, how would you suggest if we run across that to fix that? Like ask for forgiveness from the IRS, I mean from the from the Department of Revenue. I usually just send it in and say, please forgive me.
Yeah,
I didn't know any better, and they usually do.
Yeah, exactly. Just send it in.
That's what I usually do, and it usually works.
Yeah, that's what I would do. You just send it in with the
especially during COVID, it's work. But in the past, it's always worked for if you're a first timer, they usually go, oh, thanks for the money. Okay, and then usually nothing else happens.
Exactly. Yeah.
Okay. I just wanted to throw that out there in case anybody forgot to do it. They didn't know they needed to do it. Just send a forgiveness letter with the check, and usually they'll take it and cash it. Mm-hmm. Yeah.
So Andrea, Steve Mansfield, Steve, are you on here? Can you ask your question about when you're making an offer? I think this is a good time to do that, maybe. Steve Mansfield.
Well, the question's probably going to be, I think, if you're making an offer in the name of the trust.
Well, if you're making an offer on a property, period, and you want to use a land trust, how do you do that since the trust may or may not be created yet?
Right. So I actually have a slide that I'm going to get to in a few minutes.
Oh, good.
that's
that kind
gonna
of leads into Christopher's question right under that, which is, does the beneficiary have to be a natural person, or could it be another trust, LLC, et cetera?
Yeah,
So that kind of all goes in there too.
Right. So let's move on, and I've got slides on those. So
I have a
Great,
quick
perfect.
question, if you don't mind,
Uh-huh.
before you move on. You were mentioning about putting your beneficiaries to avoid probate. Does the beneficiary have to be 18 and over, or can you
beneficiary, you can have the beneficiary be you can name your children. Say you're holding a property in your
Right.
own name, and you want to name your minor children. You can do that. I mean, the bottom line is, if you were to pass away before they were of age, then they can't hold property in the state of Florida. So it would have to be held by their guardian, whoever the court appointed as their guardian.
Gotcha. And then the other question is, with doing this DD whatever 28, I'm sorry, I'm
DR
mixing.
228.
There you go. I'm sorry. I was thinking of DD 214, military, sorry. Do you have to have your social security number, or can you use a federal ID number?
Yeah, you can use a federal ID number.
Okay.
I mean, if the taxpayer is an individual, it's going to be your social security number. If it's an LLC, it's going to be the EIN number for your tax,
Well, the thing is, there's sometimes with the EIN number, it actually has sole proprietor, so you don't necessarily have to be an LLC
right. Well,
for purposes of either banking, or I can't remember what the other.
Well, you're gonna want to use your tax number that's associated with how you paid it, who paid it.
Okay.
So, yeah.
Okay. Thank you.
And this next slide is just an example of what it looks like on public record. Obviously, you've probably all seen that when there's no purchase price recorded. It's just going to be $100 sale price. This is an actual property of that we were the trustee of, and it was a probate property that was purchased and then sold. You can see the second purchase price up there, the 182. Now that was the sale price on the out. It was a flip. So that works nicely because it had been held by these people for a very, very long time. And as you can tell, previously sold for $32,000. So the investors that purchased that actually purchased it for well under $100 and then resold it pretty quickly. So it was only a little over 3 months. So it's difficult sometimes for end buyers to see that, oh goodness, this just sold for $90,000, 3 months ago, and now they think that I should pay $182,000 for it. So that's just one reason that if you can, when you're dealing directly with sellers, especially with flips, it's nice to use this aspect of the trust and try to hide that purchase price. Okay. So who can set up a land trust?
Andrea, I'm sorry, for beginners, I just had a quick direct question from a beginner. Why does it show on there just $100 on county records sometimes? Many of us have been in this a long time. We know, but beginners don't know the answer to that.
Right. It's just because the minimal doc stamps on the deed, typically there's always a small amount down there. Like, you send in, it says for the, just for legalese, they have to have some kind of consideration for the transfer. So it'll say a minimal amount of maybe $10 or maybe $100 was the consideration for the transfer. So that's what gets recorded is the actual transfer amount on the deed instead of, because there's no doc stamps being sent in with it, if that makes sense.
Do you have
Thank
to?
you. I know that's a question for a lot of beginners.
Sorry. Do you choose the amount that gets recorded in terms of the $100 or the $10, like you use as an example?
Yeah, I mean, usually most deeds say $10, I think. That, most deeds, even from a title company, are going to say that, but it's determined by the what the doc stamps are that are sent in. So, and now, honestly, with the e-recording, used to be we could send in a deed even with a minimal amount of transfer, like a $10 transfer amount, send in the deed. We'd send in a letter saying that, this is not subject to tax. But now we're finding that they want that 70 cents. So even though even though for years and years it was considered just something nominal that people put in there and just to show consideration, well, now they want it, so they're getting a lot stricter about that.
Thank
So
you.
Andrea, Hammett just chatted over here in regards back to that being a realtor and doing the listing. He said, what if the actual beneficiary wants to sign the listing agreement? The trustee was a family member who is out of state. The beneficiary can change the trust agreement anytime to remove this family member anyway. So can the beneficiary ever sign a listing agreement or not? Or does he have to change that family member to not being a trustee?
It really depends on what's on the deed. I mean, who's the title owner on the deed? Is it if it's the family member, then they better that's another thing that typically I address a little later in the presentation. But you have to be careful who you pick as your trustee. Is that trustee going to be available? So a lot of times we want to use family members, right? So you want to use your sister-in-law or your brother-in-law who's an attorney or whatever. But what if they're traveling? What if they're gone for a month? What if they're incapacitated? That's some of the issues that you have when you don't use professional trustee. So technically, it should be the title owner that signs the listing agreement. If they can change that and maybe record a quitclaim deed quickly, but even that is going to quitclaim deed is going to take whoever that former trustee is to sign that quitclaim deed.
That kind of brings up, Lenny and Ann had asked, should the trust be notarized? Is it a requirement by law that it's notarized? Why or why not is the question. So it's about notarization of those trusts too, by the way.
Right. So the trust, yes, the trust should be notarized. It actually doesn't have to be under the land trust statute, but ours are. We have ours notarized, and obviously the deed to trust is going to be notarized because the deed has to be notarized and witnessed. We actually do our land trust agreements with notary and witness.
Let's say the trust is not notarized, okay, because it's not a requirement by the statute.
It's still a valid trust.
What is something?
What
is something that we should be aware of in regards to that? Like, oh my gosh, now what? So what would be the bad thing about that?
The trust is a contract between the trustee and the individual. So the only thing about not having it notarized is so somebody could challenge it.
Okay, that goes up with the one about the beneficial interest. If you direct a trustee to change the name, of the beneficial interest, does that document have to be notarized?
No, it has to be in writing.
Okay. Very good. Thank you.
Okay. So who can set up a Florida land trust? We got any individual or group of individuals, a partnership or limited partnership, irrevocable trust or trustee, out-of-state trust company, an LLC, any self-directed IRA, HSA, 401k plan, individual K plan. We've had lots of people join in formation of trusts, and we might have 4 or 5. I think we had 5 was maybe the most we had, and they were a combination of all these things. We had an individual that partnered with I think there was 2 self-directed IRA plans on there and an LLC, and then maybe something else. So it's possible to have one of these or several of these be a partner in a trust. The one thing that all of these things have in common is they do require a signature. It's an entity or an individual who can sign documents. So they can sign the trust documents, they can sign the deeds placing the properties into trust unless it's being purchased into trust. They can sign the emails or in the authorizations, I should say, to direct the trustee. So it has to be someone or something that can set up a trust that has powers of signature. So the parties, the only 2 parties necessary to a land trust are the beneficiary, which I earlier called the settler of the trust, is more commonly known as that, They are the first person because they are the ones that have the desire to set up the trust. They are wanting to set up this trust to protect their property interest. And they contact a a trustee, to be the face of their property. So those are the two required people, the beneficiary and the trustee. Some optional people that parties that people may use is a director. We talked about that a little bit earlier. And a director really comes into play when, like in that prior instance where we had 5 beneficiaries, a couple of them were retirement accounts. Maybe I think they were small percentages, and we had an LLC and an individual beneficiary, that type of thing. When there's that many parties playing the beneficiary role, it's easier to have one person who's kind of directing the trust. Otherwise, we have to get written direction from all 5 of those. When there's we get a listing agreement, so we have to reach out to all 5 beneficiaries and say, okay, are you okay with this? Are you, send us an email. We got to make sure we've got it all documented. So it becomes a lot easier to have a director in that instance. And a lot of times that just works itself out because there's typically one person that's sort of running the show. Maybe they're managing the property. Maybe they are the, 50% beneficiary and all the other ones are a smaller amount. Not that that matters, but I'm just saying that logically, a lot of times that person will become the director. So we'll set that up that way. Another party, if you will, to the trust, or a player in this whole thing, might be a property manager. I know with Commonwealth Trust Services, we always provide a complimentary property manager agreement between the beneficiary and the trustee. As I've said before, we are, as trustee and per the statute, we are administrative only. So our role is very limited. We're not going to manage your property. We're not going to collect funds for your property. We're going to do any of those things. We're going to be the face of the property, and we're going to collect the mail that comes to it or any phone calls that may come from the public. But you're going to want to have a property manager, or you're going to want to manage the property yourself in the way of turning on power, entering into leases with people, that type of thing. That's all going to be done through the role of a property manager, whether it's you in that role as a beneficiary or you're going to hire a third party. If you hire a third party, then you would send us written authorization to sign the property management agreement with that third party. Successor beneficiary, we touched on that. That's also an optional player. If you're holding your beneficial interest in a retirement account or in an LLC, you're not going to need a successor beneficiary because you're going to have successors set up in your organizational documents. However, if you're holding your beneficial interest in your own name, then that is a very beneficial aspect of the land trust, is to name a successor beneficiary so that they can avoid probate.
Andrea, Lenny and Ann asked can the director be an entity instead of a person, an entity?
Yes. Yep. It could be an LLC, as long as, we know we have the LLC documents. We know who the person is of the LLC that's actually sending us the instructions and that type of thing.
Excellent.
Yeah. Successor trustee can be named in the trust document. Typically it's used when your trustee is going to be a person, an individual that can die or pass away. Then you might name a successor trustee. With an LLC, a corporate trustee like us, we're an LLC, that's not going to happen. Then if you want a new trustee at some point, then there's other documents we do, but that wouldn't be a successor trustee. That would be more of a replacement trustee. So the trustee, obviously, I love this slide because it shows it really has to be someone that you trust. So the trustee's only duty is to hold title to the property, to sign the documents affecting the title when directed by the beneficiary or under the terms of the trust. So it's got to be somebody that you trust, that understands their role. Number one, are they familiar with the statute? Do they understand what a trustee does? Do they understand that this property is not theirs to do with what they want? This property is held for the benefit of someone else. Will they know how to look at the documents that they're presented with, question you about the documents, get the right permissions from you to move forward? Will they be able to answer calls that are asking who the beneficiary is and deflect those calls and say, hey, I'm sorry, but, we don't release that type of information. A lot of times with family members, they get confused and they start getting bothered by calls and they start directing them to the actual beneficiary. Their knowledge of the land trust operation, their knowledge of legal issues, because it is a legal statute that you're operating under, and you're preparing legal documents if you're using a trust, and you want to make sure that they are valid, as we talked about earlier. Your use of discretion. Are they going to be able to be discreet about this property? The beneficiary is being protected, in essence, by the trustee. Their privacy is being protected. So that's their anonymity. It's also to make sure that records are kept appropriately, that this trustee is available to cooperate with a title company when things are being needed to be signed, with a realtor when listing agreements or purchase agreements need to be signed. As you know, that moves very quickly. It's listed one day and you get an offer the next day. So you have to make sure that someone is available to sign those things. The beneficiary and the trustee should not be the same person. That's our opinion. Obviously, per statute, they can be the same person, but if they are the same person, you are losing some of that anonymity, because it's not hard to put two and two together, especially if you're being the trustee of your own property. Unless you have hundreds of properties and you're putting yourself out there and advertising your services as a professional trustee, most people are going to realize that, hey, this person, that's not what they do. They're not a professional trustee, so they must be the trustee for their own properties. The beneficiary has no interest in the real estate, but instead has an interest in personal property. Now, a lot of people ask if their primary residences that are homesteaded can be held in a land trust, and they can. It's actually in the statute that they can be in a land trust. However, they must reserve those. In order to get homestead exemption, you have to have an interest in real property. So in that particular instance, we set up the trust documents different and we reserve the property as real property. So if that is the case, then because it's not personal property, you would have to transfer that property the same way that you transfer a deed, with witnesses and a notary. And we do that anyway for our assignments of beneficial interest. We require 2 witnesses and a notary, just because we want to make sure everything is done, without question, and that no one can challenge signatures and things like that. The beneficiary is going to manage the property. They're going to choose the manager for the property. They're also entitled to all the proceeds and the avails of the property. So we are not going to manage it, and we're not going to collect funds. There is a rare occasion where we get people that either they're purchasing properties where they don't get a choice in the title company, or they choose the wrong title company who doesn't understand the land trust. And a lot of times it's big, like Fidelity type closing companies, and they insist on wiring to the title owner, which of course is Commonwealth Trust Services. So we keep a trust account for that purpose, and also for insurance proceeds purposes and things like that. But we try against all costs to avoid that situation where we're getting wiring of large amounts. And it's an extra charge to our beneficiaries, because it's more work on our part and more costs on our part, because obviously there's wire fees in and out. So we don't touch anybody's proceeds. They would go directly to our trust account and be wired out to the beneficiary.
Andrea, above and beyond the wire charges, what are the fees for Commonwealth to do that for your client?
We charge $150, which includes the wire charges typically. I mean, unless there's some weird wire charges, but typically that's what we charge, $150.
Thank you.
So the beneficiary is responsible for the liabilities of the property. You are responsible for getting your own insurance. This property is in trust, but it can still burn down, so it's not protected from that. So you want to make sure you have all the proper insurances. So I already talked about the director a little bit. So the beneficiaries may empower one person to give the direction without the signature of all beneficiaries. So that's typically going to happen when you've got multiple beneficiaries. Or you might have beneficiaries that are out of state. We have had that as well. You might have a silent, more of a money partner that's a partner in your trust, and they're going to leave the management of it up to you, and they're going to allow you to make the decisions. Perhaps they don't want to be bothered and they're out of town, or they live out of state. So that's when a director really comes in handy. The director does have a fiduciary responsibility. So if you are the director, then you are, there's going to be, certain obligations, rights and obligations that you have to those beneficiaries. It's not just a carte blanche to do whatever you want with the property.
Andrea, Hemet needs you to clarify about, you mentioned the $150 per property. What if there are multiple properties, say 20 plus? So he needs clarification on your charges, I think.
No. Was he asking? I thought he was asking what the charge was if we were wired proceeds in a closing.
Yeah, I want to make sure he knows that you and I were talking about wiring proceeds is the $150 per property.
That's just facilitating wire charges, $150. That's over and above. Our fee structure is $550 to form a trust. Now, once you have a trust with us, we give a multiple trust discount of $100 for the next one. But that first initial trust includes the basic documents of we prepare the deed. Obviously, if it's a purchase, we're going to coordinate with the title company. It includes the land trust agreement, which we prepare, review with you, and also the for your first year of trustee services, which is $100 a year for us to serve as your trustee. That includes our ongoing administration of the property, receipt of any phone calls, communication back and forth with you, those types of things. Any additional documents that I might talk about, like an assignment of beneficial interest or a collateral assignment, facilitating wires, things like that, those are an additional charge. So
Hemet, if we didn't answer that question, Hemet, just put it over in the chat, and she can do that at the very end. But I think she answered that real well there. I think you got it. Thank you.
So there's 3 ways to place your property into a trust. One is to deed a property that you already own into a trust. We have a lot of people that say, "Oh, I wish I would have done this. I already have 5 rental properties. I really like to get them out of my name." We have that quite often. People can simply we'll prepare the deed. They can deed the property into the land trust. We prepare the land trust document. They become the property manager of that trust property. The other way is to purchase your new property directly into a trust. So when that's the case, you may want to actually contract in the name of the trust, or you may, which we're going to talk about in just a minute on another slide, you may just put some language in the contract that's going to allow you to close in a trust. And the third way we've already talked about is where the seller agrees to be the initial beneficiary of the land trust and transfers and assigns the beneficial interest to you. Now, this is a really easier process than it sounds like. I tried to describe it in a step-by-step way, but in actuality, it all happens very quickly at closing. It's still a purchase. It's just that the seller signing one document, placing the property into trust, then a second later, they're signing the very next document, which is assigning it to you as the beneficiary in the trust. And that's the way that keeps the purchase price private. We have had a lot of people come to us and they're purchasing their property directly into trust, and then they're surprised to find out that their purchase price is on public record. And they thought, oh, we thought it's going to hide the purchase price, but it's not a purchase of the property into trust. That doesn't hide the purchase price because the deed is still the transferring document in that case. It's just transferring it from the seller to the trustee. So the doc stamps are still going to the county in that case with the deed. So that does not hide the purchase price. So here's a contract that this is one way that you could contract as the buyer. We've used our name as an example. So it would be Commonwealth Trust Services, LLC as trustee of the 123 Main Street Land Trust. Typically, this happens when we have clients that have used us before. They call us, they're like, hey, I'm putting your name on a contract that I'm going to purchase, and it's going to go into a trust. So they will send us the contract to initial and sign as the purchaser, and it goes to Sally Seller, and then it closes in trust without any addendums or any, anything like that. Oh, I guess I thought I had a slide for the, oops, hold on. No, I guess I don't. But another way is to place in the additional terms. Say you're not sure if you're going to use a trust or not. You're right on the spot with the seller. You're going to make the offer right now. You're writing out the contract. You're going to do it in your own name or your business name. But in the additional terms section, you're going to put down that for the purposes of closing this transaction, this property may be purchased into a trust or may be closed in a land trust. So you're just going to put that additional language in there. And typically when you do that, that will avoid the need for an addendum. So I know lately we've, worked with a lot of different title companies, and some title companies are not as lenient as others in what they require. Most of them are going to require some kind of addendum that indicates that the property is being assigned or you are changing the buyer's name to a trust. So either an assignment or an addendum. And recently we had a client who they were a newer investor, and their intent all along was to try to hide the purchase price. So they had talked to the seller about using a land trust. But the seller, unfortunately, had already chosen their title company, and the title company did not understand land trust, in fact, the title company was an attorney's office. They didn't know anything about a land trust. It was outside their box, and they advised their seller that they shouldn't have any part of the buyer's trust, and they didn't understand why they were involved with it. So the seller, when we went to close the transaction and we let the buyers know that this was not going to hide the purchase price, buyers were a little upset, went back to the seller. The seller said, well, I never understood that. And because they hadn't documented that anywhere in the contract, the seller refused to change it because the attorney closer was saying, hey, you shouldn't change it. This isn't your obligation. So you really have to set those expectations up front. And I recommend either documenting it somehow in the contract that you intend to close in a land trust. And if the seller's placing it in trust, then you'd also want to put that in the additional terms. That is part of this transaction. The seller has agreed to place this property into trust. And that way it's clear.
That's very good. I think Dory DeLuca, Dory, why don't you unmute? She has a couple of questions that may be pertinent now, she thinks. She's the one in the grass there, Andrea. Hi, grass.
Hi there. You talked about that you have a complimentary property management service, and I've heard different things from different people, and I'm confused about this.
No, we don't have a property management service. We just, with our trust package, we provide a property management agreement at no charge. Or in the alternative, we sign your third-party property management agreement at no charge.
Okay, and then I've heard that that property manager has to be a realtor in Florida. And then I've also heard that it doesn't have to be a realtor if you have an ownership interest in the property. And we call it an agency agreement, but it sounds like the same thing. It's between the beneficial interest and the trustee, and it allows our other company, our public company, to sign leases and that kind of thing.
Right, that's correct. Yeah, if you're managing other people's property in Florida, then you are supposed to be a licensed realtor. However, if you're managing your own property, you have a property interest in the property, which is the beneficial interest, then you can manage your own property. Now, most lay people that you're dealing with, people that you're in rentals and things, they don't know that. So it's not We have never had a client come to us and say, oh, this is making me, non-private because I'm managing my own property. If they feel that way, I guess they've gotten a property manager and it hasn't been an issue. But yes, that's how it works.
Okay, so we do not need to be a broker.
Not to manage your own properties, no.
All right, thank you. I have questions about lenders, but maybe I'll wait until you go over
Yes,
that.
I'm going to have a section on that coming up.
Okay, I'll wait.
I have a question about, or actually maybe a clarification. I want to make sure I understood you correctly. Okay, if we put in the contracts, because we want the sellers to put the properties in the land trust. So what we're doing is we are in the contracts, the sellers are putting the properties in the land trust. So they're putting it in a land trust in their name, right? And then, so they're putting it in their name in the land trust, and then we're buying the beneficial interest. Is
Right.
that correct?
That's right.
Okay, so then what we're doing is we're literally buying that land trust as it stands, correct?
Buying the land trust, you're
So we're buying
you're
the
purchasing the
beneficial
beneficial
ownership of that.
interest of the trust.
Correct, you're buying the beneficial. So what I want to clarify is we just need to be very careful, and clarification is that the land trust is written correctly. So of course, if you wrote it, then it is written correctly, but that I just want to caution everyone that they read the land trust, that it's written correctly, or if they write it or whatever, because not all attorneys, as you know, are alluding to, that or do it, that they're always done correctly. So that, yeah, if they close it in that, but it was someone alluded, a very experienced investor alluded that if they close it in the homeowner's name, and I didn't really understand that if we buy the beneficial interest, if it's closed in that homeowner's name, then we buy the beneficial interest, that somehow we haven't conveyed the title correctly, but that sounds like we're doing it correctly.
It's happening at the same time. So the land trust agreement's being signed by the seller. So like the example here, and then they're assigning it that same day to the new beneficiary.
Correct. Okay,
Right.
well that's the way I'm doing it. Okay,
Now, if it was done a couple of days apart or something, then yeah, that's a problem. So then you've got a gap, right?
Okay.
And they're still the owner. So you've paid for a property that the seller is still the owner of.
Explain
Okay,
to me
Andrea, I
why,
need you to clarify. Yeah,
Yes,
you need to
please.
clarify that, please.
please.
Well, if you're purchasing a property from a seller and they're assigning you the beneficial interest, you want that assignment to be on the same day of the settlement statement.
What if it isn't?
That means that they're owning the property they're placing it into trust. So this does happen on occasion where, say we know there's going to be a seasoning requirement, say it's going to be a quick flip, right? So your seller's already agreed to place it in trust, and you say, hey, would you go ahead and place it in trust now? So that, because we're going to have, typically they don't want to know all that. You can just let them know, hey, there's going to be some requirements and we'd like you to go ahead and place it in trust. Now you're going to be the owner. You're still going to be the owner until we close. So they'll be the owner for maybe 2 weeks. Then you do the assignment of beneficial interest, and that's on the same day that the settlement statement is, because you're purchasing based on at the same time that you're doing the assignment. So that's the day of your closing.
Well, let's say you didn't do it like that. Where does the breakdown come in? I don't understand where the breakdown is coming in.
How else would you do it? Maybe I don't understand your question.
Okay, so sometimes the sellers, maybe well, I guess I understand what you're saying. It is correctly. They put it in the land trust for their, well, that's true, for their, for their planning, for their retirement or whatever, for their estate planning. So they do that just as, par for the course for, and then later on, I guess that would be the only reason they would do it. It's just, with our assistance, and then sometime in the future, we buy the beneficial interest, I guess.
Correct.
So that, what if for whatever reason, they just put it in the land trust prior to the closing.
Yeah, that's fine. They're still the benefit. They're still the owner until they transfer that beneficial interest.
Okay. Which is not a problem.
Right now.
Yeah. Okay. I don't see the problem either. I don't know. Maybe I'm missing something. Okay, thank you. I need to think about that. Maybe I'm missing something.
The only thing that I think you could be thinking of is they would place it into, say they place it in there a month in advance before the closing.
Yes.
So at the time they wouldn't have a title policy when they place it in, but you're still going to get your title policy. That'll be dated, it's going to ensure the trust name. Maybe the title policy doesn't go into place until, until you get transfer your beneficial interest and on the day of settlement. But that's the only thing I could see that, that he could be talking about with your transfer issues. So I don't know.
I need to get some clarification because I didn't follow it either. So I do
Okay.
need to get some clarification. Thank you.
Yep. So here's just a sample land trust agreement. We're going to set out the beneficiary's name. So here it's Sally Seller, who's a single person. It could be your LLC, it could be your retirement account. We're going to indicate the percentage of their beneficial interest because remember, there could be multiple parties. So then we would indicate in all of their percentages. We're also going to use your tax ID number in the land trust agreement because there's lots of Sally Sellers out there. So we want to make sure that we have your unique tax identification number. And we're going to do your current address, the beneficiary's address. Could be a PO box if it's an LLC. It could be, New View Trust Company's address if it's a retirement account or however that's set up. We're going to indicate the legal description for the property interest is going to go in the trust agreement. Now, if it's a mortgage, then we're going to indicate the recording, book and page, that type of thing. We're going to identify the property interest. Then there's going to be a warranty deed, and the warranty deed will indicate the trust name. And in the first paragraph, it's also going to indicate the date of the trust. So that's very important too, because there could be another 123 Main Street Land Trust. We want to make sure that it's dated properly. Here's an assignment of beneficial interest, assignment and quitclaim and beneficial interest in land trust. It's a little bit shorter than the land trust agreement. You're taking under the already established trust, which is laid out, as you can see in that second paragraph. In the first paragraph, it's going to indicate who the assignor is, the grantor. It's going to identify them by their tax ID number and their address, and it's going to assign it to the grantee, who is going to be the new owner, private owner beneficiary. That's pretty self-explanatory, I think.
Andrew,
So-
wait, in regard, oh, I'm sorry. Let's see. Go ahead about I have a question that came to me regarding assignment of beneficial interest. So go ahead and finish your part. I'm sorry. And then
That's okay.
I can ask that for you.
Yeah, so the buyer can receive an assignment of beneficial interest from the beneficiary. The advantage is the doc stamps are paid. We've already talked about this. The doc stamps are paid on the assignment rather than the deed, concealing the purchase price. So this slide kind of goes back to that first example I used of the two investors, where the one investor had purchased it in purchased it in trust. He's assigning his beneficial interest now to a new investor, and that those doc stamps are going to go directly to the Department of Revenue. So nowhere in the public record that's recorded does it show that there's been a transfer of that property. Now and then it just goes on to say it's going to be under the same trust with that same trustee. The trustee can't be changed later or at the same time. There can be documents put into place changing the trustee. If the trustee is going to be changed, you'd probably want to update the title policy, doing a title policy that ensures the new trustee. Now, I think in Florida now, there is a document required that you send into the property appraiser, which is a change of control document. which just indicates to the property appraiser that the control of the property has changed. And that is required, but it's not recorded on public record. It's kept in the private, in the, folders at the property appraiser's office.
Okay. May I ask you that question on
Sure.
assignment
Yep.
of beneficial interest? Okay. Let me read what he says here. Okay. Let's see. Okay. Husband and wife own an LLC. So both names are on the LLC. The LLC owns the beneficial interest in a land trust with a trustee who is a separate professional trust services company.
You
Okay.
broke up there. Can you back up and say the beginning of that again? I got the husband and wife, but after that I couldn't hear.
Okay. Husband and wife own an LLC. They're listed as owners of the LLC. The LLC owns the beneficial interest in a land trust. And the trustee is a separate professional trustee service company. Okay. So not a family member. Can just one person in the LLC sign the assignment of beneficial interest is part of the question. And does that have to be notarized? And this is to take it out of the LLC's name. In other words, it appears maybe the husband is going to sign the assignment of beneficial interest saying we want it to go to another company or somebody else. Does that have to be notarized? Do they both have to sign it because they're both on an LLC? If the LLC agreement says either one or can, do business, blah,
Right.
blah, blah for the LLC. Okay.
Right. So if the LLC indicates in their operating agreement that either one can bind the company, then yes, one of them can sign the assignment of beneficial interest, assigning it to someone else, and it doesn't have to be notarized.
Okay. And they can keep the trustee in place, of course, as long as the trustee agrees.
Yes. Well, the trustee
Right.
has to accept the assignment, and the trustee will, I don't think there'd be any reason for the trustee not to be, unless they're going out of business or something. It's a professional trust company. But yeah, so they would just remain as the title owner and accept the assignment.
Is there a document that says they did accept it, or is that just done and
No,
it's
it's
over?
on the same document. The trustee has to accept the assignment. So in
That's
other
right.
words,
It's at the bottom of that same document, isn't it?
yeah, you
Okay.
can't be out there just assigning your beneficial interest and, all of a sudden somebody comes to the office with an assignment of beneficial interest, says, hey, I'm the owner. Trustee's going to be like, no, you're not the owner because we never accepted that assignment.
Okay. Let me ask you this. They didn't ask this, but I'm going to ask this on top of that. So let's say you did want an assignment done and you sent that into the trustee, and for whatever reason, the trustee didn't sign that bottom part and you don't have a copy of that. It didn't get back to you. It just wasn't done for whatever reason. Can that be corrected now? Let's say it's years
Sure.
later. I don't know. Does
Sure.
it now
Yeah,
even
that could be-
even though the trustee is signing it on today's date and that assignment happened 2 years ago, is it retroactive that they do own it since 2 years ago, or only now when he accepts the assignment?
Hopefully that's not going to happen. I mean, the trustee could always backdate it as well. It's not a notarized document. So they could be something that, never got signed appropriately. I mean, the only reason a trustee is not going to accept an assignment, that's if the assignment is directed by the beneficiary saying, hey, I want to assign my property. They're going to accept it unless the assignment is not written correctly, or for some other reason it would violate the law, which I can't think of a reason. But if there was, or if he felt like the new beneficiary was, maybe trying to avoid legal activity or whatever. But I mean,
Right.
Otherwise, they're not going to not accept it. So, I mean, that, of course, that happens occasionally where everybody doesn't sign on the dotted line on the right time, or you can't gather the documents together, so it has to get re-executed. That's not a big deal.
Right. Okay, good. That actually brings up Greg Martin. Greg, can you unmute yourself and ask your question? Because I think this is a good one. We have people that do these trusts that are not done properly. Greg, can you ask your question, please?
Yeah, so it's just I think this might have been going back to what Susan was talking about. Like if you're buying an existing trust that's been there for like 2 or 3 years, and it wasn't done right, then that could be an issue, is my understanding, versus if you're, working with Commonwealth and they're creating it right now, then that's not really an issue.
Yes, in fact, that's a very good point. In fact, when people call us and say, hey, we want you to be our trustee, then we always say, well, send us the trust document. We need to review it to make sure that it's, according to the statute and it's the way we want to operate. Now, not saying, we can always do a new trust agreement. They can transfer it to us through a deed to trustee under our new trust agreement. That's how we would typically handle something like that if we didn't want to take under the other trust agreement.
Is that something that you do with the county? Because you're changing.
No. Well, yeah, the deed goes into the county, sure. Yeah,
Yeah.
It's got to be recorded.
Right. I just want to make sure people know that that's a change, so it has to be re-recorded, right?
Yeah, not re-recorded. It's the new deed. So.
Oh, sorry. Yeah.
Yeah.
Are there doc stamps with that or no?
No, it wouldn't be doc stamps because there's no change of control. So it's the same, it's the same underlying beneficiary. It's just a trustee's deed.
So as far as the assigning the beneficial interest, do homestead credits survive that, or how does that work? Is that?
Yeah, yes. Yeah, you can have homestead on a trust property as long as the real property has been reserved. That you're treating the beneficial interest as real property. That has to be set out in the trust agreement, and the county will request to see that.
So the new person that has the benefits assigned would have the advantage of the homestead.
Well, if the new is signing, well, it could be the opposite. You could have a trust property that's being assigned to a new, say an investor who's like, I'm going to live in this property. That's fine, but we need to amend the trust agreement to reserve it as real property, because when they go down to claim homestead, they will want to see that.
So if I'm tracking with you, that could actually be huge, because oftentimes when you sell a property, that's when they hit you with additional property taxes. Your property taxes go up because they bump the value of the property.
Did Andrea freeze? Andrea, can we hear you? I think she's frozen. Uh-oh. And we were just getting to the good stuff.
She's been kind of breaking up in and out all throughout the whole thing.
Andrea,
can you hear us? We saw you move, but then you froze again. Oh, there you are.
Yeah, I'm just kidding.
Okay,
go ahead.
Did you answer Joe's question? You may have been talking, but you were frozen in our world.
Oh, okay. Yeah. No, I just said that's, I think he's trying to say that, might not get reassessed because the county didn't see the transfer. So now someone has a new property to them, but it's not showing a sale price. So it's not being reassessed for tax purposes.
Well,
however, the title companies, or you're supposed to, if you close a transaction like that, you're supposed to send in a change of control form to the county indicating that the control of the property has changed. So that could trigger a reassessment. It doesn't always, but there's no guarantee.
But the homestead keeps you from getting big increases. So that's my point, regardless of.
Oh, I see. Okay. I missed what your point was.
Would that stop that from assigning the beneficial interest? If you had the homestead on there, would the new person or entity have the benefit of that homestead so that their taxes couldn't go up more than whatever it is, 3% or whatever the limits are?
They could, yes, have the benefit of that homestead. When it comes to renew that, technically, legally, the next year, they shouldn't have the homestead advantage if they're not actually living in the property anymore. So they should make that change with the county. I mean, whether or not, I know people don't always do that, but you're not supposed to do that.
Well, we bought.
One of the challenges can come if you don't do that and that person goes on into the world and buys another property and tries to homestead it. Now they have two properties homesteaded, which you legally can't do.
Exactly.
Right. But we bought this particular property that we're in now, and that we live in. It's going to be an investment property. We'll live in for 2 years. So, we want that homestead advantage if we could have set that up from before.
Right. But you're living in it. So that's different. It is your homestead. So that's not illegal. But what's illegal is when you keep homestead on a property that's not your homestead and you have homestead on another property.
Understand that. I just didn't know if the homestead would survive.
Yeah, no, it should keep it. It should survive it. Okay. So the due on sale, this might be a little out of order. I was going to talk about subject to REIA, buying subject to properties. So this, I know probably several of you out there have bought subject to properties, which means that the seller is placing a property into the trust, transferring you the beneficial interest, but they're leaving the mortgage in place. So you're buying it subject to the mortgage. You're not actually assuming the mortgage. They're leaving the mortgage in their name. Typically, that would cause a due on sale clause violation where the borrower is not to transfer the property. That's in most mortgages these days. The Federal Garn-St. Germain Depository Institutions Act of 1982 provides that a lender cannot call a loan due to a transfer into an inter vivos trust, which is what a land trust is. It's a revocable trust. So where the borrower is and remains the beneficiary. So that's the exception for the due on sale clause. So what happens is that the seller places the property in trust. So it's not a red flag to the bank. In other words, the mortgage company, okay, maybe they see the transfer. If they do, they're like, okay, it's going into a trust for estate planning purposes. Now, technically, the person's supposed to remain the borrower, but we know in effect what happens is in the privacy of the trust, then it often gets assigned to someone else. So that's often used, land trusts are often used when those types of purchases are done so that it's not a red flag to the mortgage company. A lot of times, most of the time, the mortgage company doesn't care because what happens in essence is the investor who's purchasing this property catches up the mortgage and pays the mortgage on time. And as we know, that's what the mortgage companies are really interested in, is getting paid on their assets. So we've already gone through this a couple of different times through your questions, but we're going to have an assignment of beneficial interest when you're purchasing that way. We're going to have the DR 228, which is going to send the doc stamps to the Department of Revenue. Another document that we didn't talk about because it particularly comes into play with buying a property subject to the mortgage, where the mortgage is staying in the seller's name. There's going to be a seller disclosure that you're going to want to use, and that is where he's going to acknowledge in a bunch of different ways that he is selling the property, selling all of his rights to the property. However, he's leaving the mortgage in place. So that's just a quick little thing that I like to include, just so that you understand that, yes, properties are purchased this way. Still could be a risk. It's not an absolute that the bank wouldn't call the loan based on the transfer, but it does avoid that red flag because it looks like the seller's placing it into trust for estate planning purposes.
And Andrea, I don't know if you all do this or not, but I've bought quite a few subject tos, and one thing that I have done, I think it was advised to me a long time ago by somebody much more experienced than me, but they said that it's a good suggestion. Let's say I buy the house from Mr. Brown. So when I create the land trust name, I might actually put that name in the name of the land trust. So it might be the Brown Family Land Trust, for instance, or something like that. Because a lot of banks, that looks like asset, planning is what it looks like. And so it's often, estate planning, sorry. So that's often done quite a bit. And I've done that on some of mine. Have you done that or had people do that?
No, I've heard of that, but I've actually had other people. I haven't ever dealt with anyone that's done that personally, but I have heard that when that's been done, it's caused some problems down the line, because then that property is titled with someone else's name in it. And if they've ever challenged it, well, we didn't understand this was going into a trust with our name on it, that it could cause issues that way. So we have had people suggest that to us, and we've steered them away from it just for that reason, that we wouldn't want it to cause confusion either for the buyer in the future or for anyone if it ever was litigated, that type of thing.
Good point. Very good. Thank
you. Just popped up a DR 228. So I did have one in here. This is what, was it Susie talking about this one earlier? This is, Sally Seller's gonna sign as the taxpayer. You're gonna have your EIN number down there, the amount of the doc stamps. There's actually also a worksheet that you can do. That's the second page of this. You can send that in with this form, just to show the Department of Revenue that you've done it correctly. Oh, here's the seller's acknowledgement that I was talking about, several things. And if there's many different versions of this, people make up their own. This one was from a coaching program that they provided. So there's, just basically them acknowledging all these things, that they're the owner of the property. It's in their best interest. They're fully informed, not confused, all those things. Here's the management agreement, or a sample of part of a management agreement that we provide between ourselves and the beneficiary for the management of their own property. Now remember, when this is being signed, either for purchase purposes or sale purposes, we're going to sign all documents. That's actually really convenient. Our clients love that. They don't have to show up for closings. They don't do most of the coordination with the title companies. We're doing most of it. We do everything mail away. There's very, very, very rare situation. I think we've had maybe 2 commercial deals for our clients that we had to actually go to a closing, or the banker actually came to us in one of them. But we're going to sign as authorized signer for Commonwealth Trust Services as trustee, and not personally, because the trustee has no personal liability with regards to these properties. Financing and operating in a land trust. So the lender says here, your lender should not require the property to be in your name to grant a mortgage, because the mortgage is secured by the property. That's the purpose of the mortgage. So typically what happens is the promise to pay is what the borrower will sign. Now in our trust properties, we are the borrower. We are also the mortgagor. We're signing both. Some lenders require, now we're signing as trustee. So some lenders require that the borrower, the beneficiary borrower of the trust, actually sign the promissory note, or at least sign a personal guarantee. But in essence, the property is secured by the mortgage, which the trustee is signing, which is appropriate because we are the title owner on the deed. Yeah, just what I said, the lender may receive a personal guarantee and a title policy also. Most lenders are going to require a title policy. So these are points that you want to bring out to your private money lenders to let them know that, hey, you are going to be secured. It's going to be secured by a mortgage and note. I'm going to sign a personal guarantee. You're going to have title insurance, all of those things. The lender may also require a collateral assignment of beneficial interest, indicating that they would, upon default, they already have the collateral assigned to them.
Andrea, as a point to that, that last thing, could you go, yeah, the lender may receive a collateral assignment of beneficial interest. That is signed, so is that already signed and dated on that day that the loan is taken out, and then it sits there in the file if ever needed? Or
Yes.
how does that work?
Yes, that's exactly what happens. So it's a collateral assignment that is signed at the time of the loan, typically. And the purpose of it is because the borrower is saying, hey, I'm assigning this to you now, because if I default, I'm going to, you're going to take over and become the beneficiary of the trust. So that's the purpose, so that the lender does not have to go through foreclosure. Now, if this is an owner-occupied property, they're going to have to foreclose. If it's not an owner-occupied property, and the beneficiary puts up challenges them, there's a possibility that they would have to litigate the issue. But in our experience, typically when there's one of these in the file, we haven't had those kind of issues.
And there's something there that protects your interest, so it's not going, that collateral assignment of beneficial interest isn't sitting there ready for them to pounce on you if you have paid all your payments in time. There's nothing they can do before that point.
Right. It's tied to the promissory note. I mean, you have to be in default under the promissory note.
Okay, very good. And Greg, you got a question about that. Could you state that to Andrea?
Yeah, I was just I've never understood that part of it with the land trust. So it sounds like the trustee then kind of gets in the middle and acts as the mediator almost. Like, what proof does the trustee then require to execute that?
Well, typically they would have to, there has to be, I mean, this has been done a couple times with our clients, not very often. If it becomes to a very heatedly disputed issue, and say for whatever reason the beneficiary is in terrible default and they're not going to remedy it, and they're going to fight and challenge the trustee and challenge the lender, then you're going to have to litigate that in court. I mean, the trustee's role is not to be a mediator. We're supposed to execute on documents that are already signed. But as we know, contracts that are signed sometimes get litigated. So where this works best is when you've got someone that has, agreed that, hey, I'm assigning this to you now. I have received, under the terms of the promissory note, you have given me the acceleration letter, I've been a default, that type of thing. There's cooperation and a smooth transfer without foreclosure, and the lender takes over the trust.
So that's a very important document, Andrea, and if it's not executed properly, or it's the terms and the information is not properly on there, it could be abused by let's say it's a private lender, it could be abused by the private lender, or on the other side as well, I guess. But the main thing is you need to get that wording correctly on that collateral assignment of beneficial interest.
Right.
Right.
Yeah.
I mean,
yeah, and
I can't emphasize that enough.
Right. And you also might want to have a UCC1 filed as well, because your interest.
Wait now. Now you're doing that lawyer thing. What's a UCC 11555 or whatever?
UCC1 is the Uniform Commercial Code. You can actually file a security interest on personal property. So that could also be another tool that you'd want to utilize in conjunction with the collateral assignment, and notate that. And that's another, there are some law, it's kind of, this really hasn't been litigated a lot, honestly, it's in Florida. But there's there's case law that says that you have to foreclose, but then there's also statutes on the books that say that if you have a collateral assignment and a UCC1 filed, that the court will uphold that. So, but like I said, it's not been litigated a lot. But when you require those things to be signed, these are just all things that you can do a lot of it's a mindset, right? You're entering
Right.
into this partnership with your lender's trusting you, you're agreeing, all these things are written out clearly and you've agreed to them. So that's where it really comes in important to have the documents identified, have people reviewing them, signing them, and understanding what they're doing.
Yes, so it does not prevent Greg and I from being jerks, but it does help the lender to feel a little more confident that we're going to do what we say, I guess, right?
Exactly.
Okay, so Greg, you hear that? You and I cannot be jerks. That's it. We don't want to be the first one's cases.
Yeah, I just, the part that, so it makes sense for the lender to me. The lender would definitely want it, and it's good for me to give it to the lender. But my question is, so what if you do that so that I don't disappear, I'm assuming, so that 5 years down the road, I'm in default and you can't get a hold of me. The paperwork just switches over to them without me having to sign paperwork then. But so
Right.
What happens if I've not been responsive? Like, where's the proof of the default? Like, what if I've paid my payments and they're just saying that I'm in default? Like, I haven't been in default, so maybe there's more to it than I
Right.
realize.
I mean, if you've not been in default, first of all, we're not just going to do, the trustee's not just going to do that without, communicating with the beneficiary.
Okay.
So a beneficiary that's not been in default typically can be found. So a beneficiary that's not been in default that can't be found is usually more suspect. I think we did have one where actually the lender, we went months and months. The lender was contacting us trying to resolve this situation. We had a collateral assignment. We're not eager to act on those, of course. We're continually trying to get the beneficiary, could not get him. He obviously hadn't paid. So it's a process. I mean, it's not something that we're jumping up and saying, okay, yep, now you can have just based on your word. That's not how it works.
Right.
I mean, there's notices that have to be given according to the promissory note. Number one, default notices. Just like a bank. I mean, a bank's going to start foreclosure proceedings, they're going to give lots of notices first before they do that. So
What are those default notices that need to be given? Are they like a foreclosure? Is it like
yes, just like a default notice that a bank would give. It's got to have everything set out, what the default is, what's the payments that are being missed, all those things, what's owed, and a remedy time, just like your note provides for.
So if you pretty much followed what you would do if it were a foreclosure, just minus the foreclosure, really.
Exactly. You're going to send them a notice just like you were going to foreclose on them.
Okay. Because I've seen a UCC1, it's very common with those like sheds, those big sheds, because they are typically personal property because they just pick them up and take them away. I've seen those before with that, the UCC ones with that, because they're very valuable, but they can just come and, kind of forklift them and take them away.
Right.
So I have seen those, but then they're still they still want to get paid, but they can pretty well repossess them, quote unquote,
right.
Like that as personal property. So I could see that. Okay. Thank you.
So different types of loans, private money, hard money, traditional bank financing, private money and hard money. We found lenders like land trusts. They feel more secure. The other reason besides the things we've already talked about, is they like the fact that the property they're lending on is going into its own trust that is not going to be affected by the other things going on in your life, the other lawsuits you might be involved in, and maybe you get a judgment or other properties that you may have. So private lenders like that. It sort of keeps your property that they're lending on apart from your other properties. Now, traditional bank financing, we have had only a handful of banks, and they weren't big banks. They weren't like Bank of America's. but smaller banks that did loan to properties in trust. But typically that's not going to happen. It's, you know, outside their wheelhouse. They don't understand it. And we have a lot of people that refinance with, you know, Bank of America's or Wells Fargo's or banks like that. And we typically have to deed it out. They do their refinancing, then they deed it back into the trust after that. There's protections for the borrower, obviously. There's privacy, is the trustee signing the note, and the mortgage. The mortgage is the recorded document. So even if the borrower also signs the note, that's not going to be recorded. So that keeps the public from seeing exactly, you know, what you've borrowed, basically what your leverage is on public record. Your credit staying clear of multiple encumbrances. And as we talked about, it's the ease and privacy of partnerships and joint ventures. When you go into a joint venture with, you know, 1 or 2 or 3 partners, it's kind of messy to have all of that all over the mortgage. But this way you're actually, you know, you're partnering in a trust. And so just the trust is becoming the borrower. Protections for lenders, you're going to have personal guarantees, you're going to have hazard insurance where they're listed as an additional insured. You're going to have a title policy, and typically they're going to have a lender policy. And sometimes, depending on the situation with the lender, maybe, you know, if they're lending the entire amount, if they're going to take part in the property management or some such thing, they might be a director of the property. We haven't seen that happen too often. Well, actually not often at all. I think maybe one time, and that was with a newbie investor, and the lender was really more like taking them under their wing. So they were going to be a director of the trust property. And then, of course, the collateral assignment of beneficial interest, which we've talked about. Beneficiaries agreement, I mentioned that earlier. It's really a good idea when 2 or more individuals are owning interests in trusts to at least have some kind of a structure. This does not have to be prepared by the trustee, but it can be prepared by the beneficiaries and then kept in the file. The trustee can accept it. So that he's basically acknowledging that he, you know, they will abide by the agreement between the 2 beneficiaries. So that would come in play if there was a sale, say, of one of the assignments of beneficial interests. One of the beneficiaries wanted to sell it. Maybe there's a right of first refusal in that beneficiary's agreement that the trustee would then make sure is abided by, those types of things. Obviously, it's not necessary if it's a married couple that owns the beneficial interest in an estate by the entireties. They're not going to have a beneficiaries agreement. It should contain certain provisions to avoid double taxation, securities law violation, contributions. This is a bunch of legalese. We have like a sample beneficiaries agreement. It's more like a joint venture agreement that, you know, really will address all of these types of things: withdrawal by a beneficiary, death of a beneficiary. If you really want to make sure you're covered in all aspects, then you could use one of those more detailed beneficiary agreements. Most of our clients are more concerned with the day-to-day operation, like let's outline how this is going to work realistically. Because a lot of people are partnering in their LLCs, so they're not as worried about death and default, because obviously if they die, their LLC is still going to continue on. But they're more concerned about, hey, you know, who's going to be keeping the checkbook, who's going to be, you know, contributing to the renovation funds if it goes over, that type of thing. So, and I think too, a lot of the times those agreements get done between the beneficiaries and they never make it into the trust file. It's just something that they document between themselves, which is still very, very helpful and a very good idea, so that people set their expectations up front. We've talked about the right of first refusal. Beneficiary wishing to exercise a right must strictly comply with the terms. Or you may have an option to purchase each other's interest in the event of death or withdrawal. You might want to consider, like I just talked about, division of profits, collection, deposit, disbursement of funds, maintenance of books and records. Who's going to keep the records? Is that one person? Are you both going to keep records? I know when I do flip with a partner, typically one of us is in charge of the spreadsheet and shares it with the other one. And there's usually one of us making all of the entries and things like that, handling the funds. Expenses, documenting the expenses and keeping track of the contributions. And operating agreements for your LLCs. Those are important. With that, somebody's question a little while ago about signing, one person signing. We always ask, we get asked that all the time. They have a LLC either with a spouse or with other family members or maybe with a partner, and only one of them is available to sign. And I'll say, well, that's fine, but we need a copy of your operating agreement to have on file so that we can have the authority for that. We talked about this already. Somebody else asked about obtaining insurance. So it's your duty to obtain the insurance. We will definitely sign the application because that'll be required by the insurance company. You can forward that to us as trustee. That this is wrong. I'm sorry, I thought I fixed this slide a while ago, but the trustee should be the primary insured and the beneficiary should be the additional insured. Doesn't have to be, as I've explained with us, because we have a trust agreement. If you're using an individual beneficiary, individual trustee, then you would definitely want to be down as an additional insured. The policy could be issued in the name of the trustee and the beneficiaries of the trust as their interests appear. And that just means, beneficiaries as outlined in the trust agreement. We talked about this a little bit already, putting multiple properties in a land trust. We recommend that each property be in its separate trust. Doesn't have to be, but you do lose some lien and judgment protection benefits when you keep them in the same trust. Logistically, it can be a little difficult for sometimes the deeding in and out too. If you're using the same trust over and over again, can be a little confusing on public record as well and with title companies. So with several properties in one trust, a judgment against one will be a lien against the other. And it's not easy to sell or option the beneficial interest for one property in a multi-property trust. Same trustee can be used for any number of trusts. Each trust should have a different name or number to avoid confusion. So properties are sold two ways. The trustee can deed the property to the purchaser. The trust either ends or is kept by the seller to hold the financing. We've had several clients do that. They sell the property out of the trust, and then we amend the trust to hold the financing instrument. Or, as we've already talked about, the beneficiary can assign their beneficial interest, and the buyer becomes the new owner of the property, of the trust property. Lease option agreements are great with a land trust. The property manager can lease the property, while the trustee, at the direction of the beneficiary, may sell an option to purchase the beneficial interest in the property. So that becomes important. You want to keep that separate. You want to make sure your lease agreement with your renter is different than your option agreement. Because you don't want that to be tied together so that you have to foreclose on them instead of evicting them. So with Commonwealth Trust Services, it's really easy to order your trust. You can go to yourlandtrust.com. We ask for 5 things. We ask for your information. We ask you to upload either the contract, your purchase contract, or if you're deeding your own property into trust, your deed. We're going to ask you about the property for you to input the property information, which we're also going to see in the contract. If you have who your initial beneficiary is, because sometimes we have, like Milton, for example, is one of our clients that he's used us repeatedly, and he also uses us for his clients. So he might be the one ordering the trust. So in that instance, we need the beneficiary information and the successor information if there's going to be a successor. Choice of your property manager. If you're not going to manage your own property, then you need to let us know who the property manager is going to be so that we can indicate that in the management agreement, or we'll know to be on the lookout for a manager agreement. So these are things that we've really simplified our order form to online. So I don't even know if you have to put in, if you're uploading the contract, you might not even have to put in the trust asset information anymore. So just to wrap up, because I know it's getting late. I think I've gone way over. Sorry about that. But with Commonwealth Trust Services as your trustee, you can keep your ownership private and reduce the risk of your lawsuits. You can keep the sale price hidden in some circumstances that we've talked about when the assignment is the transferring instrument. Transfers of ownership are private and unrecorded within the trust. You're going to have lien protection between properties and between you and your properties and yourself. You're going to be able to avoid probate if you name successor beneficiaries. You can have safer joint venture partnerships, and it's more attractive to lenders because you're keeping your property free of judgment risks, and you're able to give them some additional assurances within the trust. You avoid partition. We talked about that with multiple owners. If you're on the deed together, they're going to be able to force you to sell the property. Within a land trust, that's not an option. Safer structures with regard to lease options and subject to deals, which is purchasing with the mortgage in place. So that's the end, guys. And I really appreciate your attention through all of this. And there were multiple questions. I hope that you learned a lot and that the questions were answered clearly. You can certainly go to our website, yourlandtrust.com, and we have a lot of other information. We have some videos on there. All of our contact information is on there.
Yes, this was great information, Andrea. And we have a couple of quick questions, and then, and this is all I have unless someone else has something quickly before we wrap up. One of, let's see, something that came directly to me was about personal property trust. Can a personal property trust, and you may have already answered this, I don't remember, but can personal property trust own a beneficial interest? Can personal property trust be a property manager?
I'm sorry, you broke up. I couldn't, I heard personal property trust and that was it.
Okay. All right, let me try again. Can personal property trust own the beneficial interest? Number one. Can personal property trust sign the property management agreement and be property managers on their own property?
Yes. Yes, they would be treated just like any other revocable trust. If they have a trustee, then they can do that. They can be the property manager and they can sign, they can be the beneficiary, no problem.
Okay. And then the second person, let's see, asked this. If they presently have a property that's in a land trust and they have a trustee on there that's not them, and they need to change the name of the trustee only, how do they do that with the county, or do they need to do that with the county? I know the answer to this, but I'm asking you to answer it for them.
Yeah, the statute provides that you can do a declaration of a new trustee, an affidavit, and that can be filed with the county. The problem that we've run into is that the county doesn't always record that in the right sequence, and then they don't change the name on the property appraiser to reflect the new trustee. So a lot of times we will just do a new deed from trustee to trustee. And that way it definitely gets recorded properly on the property appraiser website. But yes.
Okay, so this is someone I have to text this back to them. So you want to do a you need to do a new deed.
Well,
from
you
trustee to trustee.
don't have to do a new deed. You can do an affidavit declaring a new trustee and record that. But our experience has been that everything doesn't get changed properly when you do that. So we've started just doing deeds between the trustees. If the other trustee is living and you're just doing a substitute, a new trustee, you can simply deed it to the new trustee, and the new trustee is taking under the land trust agreement that's already in existence.
And I think that also fits Mr. Mack here on our group, does trusts and things. And he made a comment that a trust can be amended to correct a deficiency. So when we were talking about problem trusts in the past,
Right.
is that easy to do, Andrea, to do
Yeah.
the correction to correct that deficiency?
Right. We just do a simple amendment to the trust. It's doesn't have to be recorded unless there's something defective with the deed, with the trust powers. Then we would have to record an additional, a correction of the deed to add certain trust powers. But if it's just a deficiency in the trust agreement, then certainly you can do an amendment. And we amend them as well if, like we were talking before, if it has to go from a non-homesteaded property to homesteaded property or vice versa, we amend the trust.
Wow, man, this was a lot of great information. And you know what I really appreciate? That you took these questions as we went through. That's not always easy for our speakers, but you did it, and you did it gracefully and beautifully. And then that way the right material got in there at the right time. I so appreciate that very, very much. So I'm going to officially end our meeting, our meeting, and then we'll go on to the happy hour meeting. Everyone can stay that would like to. So you're welcome to stay on. But for now, I want to thank you all again for being here, and a special, special shout out thanks to Andrea for giving us a great evening tonight. Let's give her a big virtual applause. So much appreciation. This was, amazing, good information. So in the final true spirit of PCREIA's motto of investors helping investors, I ask all of you to please seek out others to support in our community, make a difference in someone's life. Thank you all for inviting us into your home tonight. Be safe. God bless. We're here for you, and we will see you at the next gathering. Yay, Andrea, please stay a few minutes for our after the meeting, I hope, just for a minute or two, please.
Okay.
Okay.
I don't know if she has something.
Yeah.
Dory has her hand out. Dory.
Oh, I'm sorry, Susan. Okay, you got it. Dory, yes, please
in the
ask your
grass.
question. I know.
I was holding my question on the lending. It's
Oh, okay, let's do it.
3 parts.
Liz, did you want to stop the recording?
No, not yet. This is a good question. Let's grab this in here. Thank you, Joe. But yes, after this.
I've actually got 3 parts. One was when you were talking about collateral assignment and of the beneficial interest and recording a security interest on personal property. Don't both of those mean that you're foregoing due process in Florida? And then my second question is that I'm trying to do some refinancing. All my properties are in land trusts, but the lenders are saying that IRS regulations have changed and do not allow lending to land trusts. I think that's BS, but if you know something where it's getting hung up that I could work through, please let me know. And the third one is when you transfer it out of the land trust in order to get the loan and then transfer it back, what do you need to do to protect your privacy in that process?
Number 2, I can tell you I don't know anything about that on the IRS. If that's true, that's news to me. We did just, I'm trying to think when the last time was within a year that there was a property financed by a bank in a trust. So I'm not sure about that, honestly. Number 1, there is definitely an argument of the foregoing.
Can you repeat that number 1 question, Andrea, so we know what you're answering, please?
The number 1 was the avoiding the due process in Florida. And that's, Florida is a judicial state. It's not a deed of trust state. So that's definitely, like I said, it hasn't been litigated a lot, but there is, Freddie Mac has a collateral assignment for beneficial interest in a land trust that they file in conjunction with the UCC1. So it's just, you put all these things in place and you hope that it's going to work. There's not a lot of case law on it. But like I said, if people are going to, if it comes down to it and the beneficiary is not going to agree, they're going to, hire an attorney and they're going to fight it, then yeah, you're probably going to have to litigate it. So if you're going to have to litigate that, you might as well go ahead and foreclose. We haven't had that. I don't know. We haven't had those types of issues crop up very often at all. And typically it's, they're able to work it out. And like I said, I think with Liz a little bit earlier, it's a mindset too with borrowers. I mean, borrowers are agreeing to many things. Yeah, they're signing a mortgage, agreeing that they're going to, these obligations under the note that they can be foreclosed on. And then they're also saying, hey, I'm agreeing that I'm not going to make you foreclose. Now, if they renege on that and they hire an attorney and they force you to foreclose, then in Florida, you're probably going to have to do that. I think there's a lot better argument with the personal property if in avoiding foreclosure, the lender not having to do it if there's a UCC1 filed and that is indicated in the collateral assignment. So we'll see. What was the third thing? Oh, protecting your privacy. If you have to deed the property out to refinance it and deed it into your own name, there's not a lot you can do to protect your privacy on that. The one thing I will say is once you deed it back into your own name, if people are searching for what you own, they're searching under your name, they're not going to be able to, you can't search the property appraiser by former. What did these people used to own? There's no search for that. It's only currently. So if they know that you own that property, yeah, they're going to be able to look and see that you deeded it out and in. If they don't know that property's ever been connected to you, they're not going to be able to find it under your name once you deed it back in.
What about using an LLC with a management trust for the managing member? Have you seen lenders that will accept that?
Not
as a commercial.
I haven't really seen. No, we haven't really seen that. I mean, maybe that's an option. I haven't seen that used as a tool. You mean instead of doing a trust?
Instead of doing anything that has my name on it.
Oh, to refinance? Yeah, I mean, most lenders that I'm dealing with that are requiring people to deed it out into their name, they don't even want them deeding it to their LLC. So unless it's a pretty long established LLC with some financials, they're not going to loan to that LLC either. That's what I see. But I mean, I'm not, for the most part, our clients, we have probably less than 25% have a lot of larger commercial properties. Most of ours are, creating their wealth through single family homes and trying to refi the odd one, that type of thing. So most of those, they're requiring them to deed it to their name, they're refining in their name, and they're deeding it back.
I want to thank you for your valuable information. Your answers are so spot on. And I think about how much it would cost to talk to a lawyer for this amount of time to get all this information. And most of the lawyers you would talk to wouldn't have the information anyway.
Yeah, that's so true.
Hey, Dory. I just sent you a message in the chat. Email me a question and I'll try to ask that in terms of you trying to get that loan with your trust. If I could try to get some answers for you, I'll put some feelers out and see if I can get that answer for you, if that would help.
Lenders, you mean?
Huh?
You know some lenders?
I know some people, yes.
Okay, great.
All right, and I'll try to help you out with that.
Thank you.
You're welcome.
Andrea,
Yes.
just a quick question, and you may have covered this, and I probably missed it, but when you're changing trustees, or if you wanted to change a trustee, or if I wanted to take my property and put it into a trust, how often do I have to pay that doc stamp and do that whole transfer thing?
No, if you don't change, if you're not changing the control on your property, you don't have to pay the doc stamps. Doc stamps are intended for transferring it to different people. You know, a lot of times people bring on partners. All of a sudden they, you know, they're going to transfer this property is going to become theirs with a partner. Doc stamps would have to be paid on that because
Okay,
you're
so
actually changing
when I sign
control.
it. Okay.
Now, one thing you might want to make sure of, though, Joe and everybody, is there may be a taxable event. So you need to check with your accountant regarding any taxable event. Because I know someone that made a little mistake about that. So yes, doc stamps, and that's all one thing, but at your personal or business tax event might occur if there's a change in things. So
If I
just
move it into a
remember
trust,
that.
There might be, is that what you're saying, Liz? If I move this?
Yeah.
into the trust?
Yes. Yes, you need to look into that a little further. I don't have any answers for you. I'm just saying that maybe something you want to look into.
In other words, if you change it from your LLC, even though it's a single member LLC, and you put it back in your own name, that's a taxable, although doc stamps aren't due, that's going to affect your taxes probably. That's what you're talking about, right, Liz?
Well, yes, actually, that's interesting you should say that. So what I was told is if it's an LLC, you might be able to have the argument that it's not a taxable event. But if it's a sub-S corporation or a regular corporation, then absolutely there could be a huge taxable event. Okay. And I'll give you an example of that, or at least what it was told to me. So someone buys a property for $50,000, let's say, and they put it in their corporate name. Not LLC, but a regular corporation, S corporation. And then they buy it for $50,000. So a couple of years later, they decide, oh, shoot, I should have put that in a land trust. So now they change it to land trust. Now, even though they own the corporation, by changing that over into a land trust, okay, then they were told that that is a taxable event. And now the property's worth $100,000 instead of the $50,000 they originally paid. So I don't know the answer to that. I'm just saying that's what I was told.
Changing just deeding a property to a land trust and not changing the beneficial interest part. Like, in other words, your LLC owns it and now your LLC is going to be the beneficiary of the trust?
No, the corporation is a sub-S corporation owns it, and they're going to put it into a land trust. And I guess they could put the beneficial interest as the LLC, as the sub-S corporation, or not. So you're saying
if it stays the same, if the owner becomes the beneficiary, I do not believe, according to my accountant, that is a taxable event. But that's an accountant issue more than me. But if they're not changing the structure of how they hold the interest, because all your taxes are flowing through to that tax entity. So what's the difference? All you're doing is changing the title owner. So if you're paying
I agree with you.
Your LLC and your LLC becomes the title owner in trust, there should be no taxable event for that.
Yes, I absolutely agree with you. And I was shocked when that person told me, because according to them, when it's hearsay, you don't know. And I don't know all the pieces. Maybe there's another piece to this, but the bottom line is they actually had to pay additional taxes. So that's why they felt they had that experience. I don't know, but something definitely that we all need to check with our accountant. Yeah.
That's the important point, is just ask the question. Yeah, thank you. That's great.
Yeah, we may not have the answer tonight, but we know to have the question.
That's half the battle.
I had a question for Dory.
Okay, Mac, you have a question?
I had a question for Dory.
Here?
Yes. Pop up there.
She actually popped up.
The information you got from the bank about the IRS, did you question what regulation they were quoting?
No. No, and I got it from more than one place. It was a bank and a private lender both, that they stopped doing land trust. They both used to, and they both stopped.
I'd like to know what that statute or what that regulation is.
Yeah, that's a good point, Mac.
Requiring them.
Especially with the bank, Dory, they ought to be able to tell you exactly.
I'm gonna call somebody, I'm gonna call.
What did Susan say?
I don't know. That's how she sounds in real life sometimes. Susan, we couldn't hear you because you were like vibrating or something was happening.
Computer out. I said, I'm gonna call Dave Dinkle tomorrow and ask him, he'll know.
Oh, good idea. Yeah, very good. So
Appreciate
Susan
the
will give
shout
us
out
a
on that.
report on that. Yeah,
And
next time. That's a good one.
And I just put out my feelers, so I'll let Dory know, and actually I'll let Liz know so she could pass the word out.
Okay, sounds good.
That'll be very interesting.
So information to be continued. I'm going to turn the recording off now, just so everybody knows. Okay, and